can commence a popular initiative for the amendment of the Constitution of Kenya and utilize funds in the initiation and pursuit of the process. It is sought the invalidation of the entire process, resulting in the publication, approval, and passing of the amendment bill. The fifth petition was number E402 of 2020, Justice Juma and Isaac Ogola versus the Attorney General and others. The petitioners raised the question whether the creation of 70 constituencies by the by the promoters in the amendment bill was unconstitutional, since the function of the limitation of the constituencies is vested in the IEBC. They urged the court to declare as unconstitutional and annul the creation of the 70 constituencies in the amendment bill. The sixth petition was number E416 of 2020, Morara Omoke versus Raila Odinga and others. The petitioner raised the following issues. A, whether the Constitution of Kenya Amendment Bill 2020 can be submitted to county assemblies for consideration, tabled in Parliament for passing or rejection, and transmitted to a referendum in the absence of a legal framework for facilitating the same. B, whether the amendment bill can be transmitted to a referendum before a nationwide voter registration exercise. And C, whether the use of public funds by the President and Honorable Raila Odinga in the initiation and facilitation of the process culminating in the tabling of the amendment bill in Parliament is unconstitutional. And D, whether Parliament has power to act upon the amendment bill following the declaration of its unconstitutionality for want of enactment of the 2/3 gender laws and the advisory opinion by the Chief Justice to the President for its dissolution. The petitioner prayed that the court declares as unconstitutional and invalidates the entire process culminating in the publication of the amendment bill. Petition number 7 was E426 of 2020, Isaac Alucher versus Uhuru Muigai Kenyatta and others. Petition number 7 was the substantive question raised by the petitioner was whether the President has power to initiate an amendment to the Constitution of Kenya in the manner relating to the amendment bill and to use public funds in such a process. He contended that the steering committee had converted an illegal presidential constitutional change initiative into a popular initiative. He sought a declaration on unconstitutionality and the invalidation of the entire process. Worthy of notice is that this petitioner sought certain declarations against the President in his personal capacity. And the last petition was number number 2 of 2021, Muslims for Human Rights, Uhuru versus Independent and Electoral Boundaries Commission, and others. The main contention by the petitioner was that the IEBC cannot undertake verification of signatures and registered voters without an enabling legal framework in place, and sought a declaration to that effect. I'll now summarize the responses to these petitions. The Attorney General filed grounds of opposition, raising a total of 12 grounds, which I shall summarize as follows. He stated that a declaration that the Constitution, the provisions founded under Article 255(1) of the Constitution forms the basic structure, entrenchment clauses, and eternity provisions of the Kenya Constitution and cannot be amended under Article 256 of the Constitution or through a popular initiative under Article 257 of the Constitution would be against the express provisions of the Constitution, including Article 255(1), which will have been rendered odious. He added that the petition did not meet the established legal threshold of justiciability for want of ripeness, that the interpretation propounded by the petitioner runs contrary to the constitutionally prescribed purpose, mode, of interpretation by negating express purposes of Articles 255, 256, and 257 of the Constitution, and that any comparative analysis of foreign jurisprudence could not be used to either contradict or supplement the text of the Constitution of Kenya, that the petitioners were invoking an advisory opinion jurisdiction which the High Court cannot give. The Speaker of the National Assembly, who was the second respondent, raised 9 grounds of opposition. He concurred with the arguments advanced by the Attorney General with regard to justiciability and ripeness. In addition, the Speaker of the National Assembly contended that the petitioners were preempting how the National Assembly would exercise its mandate with respect to the amendment bill, and that the issues advanced could have been tabled before Parliament during public participation exercise as envisaged under the Constitution of Kenya 2010 and the standing orders of the House. The second respondent further argued that the High Court lacked jurisdiction to intervene in active parliamentary processes, and therefore any challenges to the amendment bill had to await the completion of the legislative process before the jurisdiction of the courts can be invoked to challenge the bill. The Speaker of the Senate, who was the third respondent, also filed grounds of opposition, raising 8 grounds. He reiterated the grounds argued by the Attorney General and the Speaker of the National Assembly. He stated that the people of Kenya have the sovereign right to amend the Constitution in the manner prescribed under Articles 256 and 257 of the Constitution. On their part, the BBI Secretariat and Honorable Raila Odinga filed consolidated grounds of opposition, raising 10 grounds, most of which were a replica of the grounds raised by the first, second, and third respondents. They also filed an affidavit that was sworn by Mr. Dennis Waweru, who stated that he was one of the co-chairpersons of the BBI Secretariat, and its co-chairman was Honorable Junet Mohammed, that the Building Bridges Initiative was created and mandated with the task of initiating a constitutional amendment process and unifying Kenya among other functions. Mr. Waweru deposed that Article 1 of the Constitution of Kenya 2010 vests sovereign power to the people of Kenya, and such power is to be exercised only in accordance with the Constitution of Kenya 2010, that the Constitution is not a rigid document, and pursuant to Articles 255, 256, and 257, it can be amended as provided for in the said provisions, that if the framers of the Constitution did not intend that the Constitution be amended, nothing would have barred them from having such an express provision included therein. Regarding the doctrines and theories of basic structure, constitutional entrenchment clauses, and unamendable constitutional provisions as proposed by the petitioners, Mr. Waweru stated that they were mere theories and hypotheses only applicable in different jurisdictions and relevant depending on the special circumstances of each jurisdiction. The IEBC contended that in the exercise of its powers under Article 257, it enjoys constitutional and administrative, decisional, and financial independence, that it carried out its constitutional mandate of verifying that the constitutional amendment initiative was supported by at least 1 million registered voters, that it was erroneous for the petitioners to argue that there was no legal framework for verification of registered voters, as the provisions of Article 257 made it possible for the actors to know their obligations, and therefore there was no basis of making any finding against it. In respect of the petition by Mr. Isaac Alucher challenging capacity of the President to initiate a popular initiative for amendment of the Constitution, the President did not respond to the petition at all. However, the Attorney General filed grounds of objection, stating in the earlier that the President, Uhuru Muigai Kenyatta, cannot be sued in his personal capacity for any acts done during the pendency of his presidency, that the issue of constitutionality of the president's functions is res judicata, and that monies expended on the president's constitutional functions could only be audited by the Auditor General, the court could not be involved in such an issue. Having perused lengthy affidavits, written submissions, copious authorities, as well as oral submissions by counsel, the High Court made the following declarations. A, that the basic structure doctrine is applicable in Kenya. B, that the basic structure doctrine limits the amendment power set out in Articles 255 to 257 of the Constitution. In particular, the basic structure doctrine limits the power to amend the basic structure of the Constitution and the eternity clauses. C, that the basic structure of the Constitution and the eternity clauses can only be amended through the primary constituent power, which must include 4 sequential processes, namely civic education, public participation and collation of views, constituent assembly debate, and ultimately a referendum. 2, a declaration is hereby made that civil court proceedings can be instituted against the president or a person performing the functions of the office of president during the tenure of office in respect of anything done or not done contrary to the Constitution. 3, a declaration is hereby made that the president does not have authority under the Constitution to initiate changes to the Constitution, and that a constitutional amendment can only be initiated by Parliament through a parliamentary initiative under Article 256 or through a popular initiative under Article 257 of the Constitution. 4, a declaration is hereby made that the Steering Committee on the implementation of the Building Bridges to a United Kenya Task Force report established by the President via Kenya Gazette Notice number 264 of 3rd January 2020 and published in a special issue of the Kenya Gazette on 10th of January 2020 is an unconstitutional and unlawful entity. Number 5, a declaration is hereby made that being an unconstitutional and unlawful entity, the Steering Committee on the implementation of the Building Bridges to a United Kenya Task Force report has no legal capacity to initiate any action towards promoting constitutional changes under Article 257 of the Constitution. Number 5, number 6, a declaration is hereby made that the entire BBI process culminating with the launch of the Constitution of Kenya Amendment Bill 2020 was done unconstitutionally and in usurpation of the people's exercise of sovereign power. Number 7, a declaration is hereby made that Mr. Uhuru Muigai Kenyatta has contravened Chapter 6 of the Constitution and specifically Article 73(1)(a)(1) by initiating and promoting a constitutional change process contrary to the provisions of the Constitution on amendment of the Constitution. Number 8, a declaration is hereby made that the entire unconstitutional constitutional change process promoted by the Steering Committee on the implementation of the Building Bridges to a United Kenya Task Force report is unconstitutional, null and void. Number 9, a declaration is hereby made that the Constitution of Kenya Amendment Bill 2020 cannot be subjected to a referendum before the Independent Electoral and Boundaries Commission carries out nationwide voter registration. Number 10, a declaration is hereby made that the Independent Electoral and Boundaries Commission does not have quorum stipulated by Section 8 of the IEBC Act, as read with Paragraph 5 of the second schedule to the Act, for purposes of carrying out its business relating to the conduct of the proposed referendum, including the verification of signatures in support of the Constitution of Kenya Amendment Bill and Article 257(4) of the Constitution submitted by the Building Bridges Secretariat. Number 11, a declaration is hereby made that at the time of the launch of the Constitution of Kenya Amendment Bill 2020 and the collection of endorsement signatures, there was no legislation governing the collection, presentation, and verification of signatures, nor a legal framework to govern the conduct of referenda. Number 12, a declaration is hereby made that the absence of a legislation or legal framework to govern the collection, presentation, and the verification of signatures and the conduct of referenda in the circumstances of this case renders the attempt to amend the Constitution of Kenya through the Constitution of Kenya Amendment Bill 2020 flawed. Number 13, a declaration is hereby made that county assemblies and parliament cannot, as part of their constitutional mandate, to consider a Constitution of Kenya Amendment Bill initiated through a popular initiative under Article 257 of the Constitution, change the contents of such a bill. Number 14, a declaration be and is hereby made that the second schedule to the Constitution of Kenya Amendment Bill 2020, insofar as it proposed to predetermine the allocation of 70 constituencies, is unconstitutional. Number 15, a declaration be and is hereby made that the second schedule to the Constitution of Kenya Amendment Bill 2020, insofar as it proposed to direct the Independent Electoral and Boundaries Commission on its function of constituency delimitation, is unconstitutional. Number 16, a declaration be and is hereby made that the second schedule to the Constitution of Kenya Amendment Bill 2020, insofar as it proposed to have determined by delimitation the number of constituencies and apportionment within the counties, is unconstitutional for want of public participation. Number 17, a declaration is hereby made that administrative procedures for the verification of signatures in support of constitutional amendment referendum made by the Independent Electoral and Boundaries Commission are illegal, null and void because they were made without quorum, in the absence of legal authority, and in violation of Article 94 of the Constitution and Sections 5, 6, and 11 of the Statutory Instruments Act 2013. Number 18, a declaration is hereby made that Article 257.10 of the Constitution requires all the specific proposed amendments to the Constitution be submitted as separate and distinct referendum questions to the people. Number 19, a permanent injunction be and is hereby issued restraining the Independent Electoral and Boundaries Commission from undertaking any processes required under Article 257.4 and 5 in respect of the Constitution of Kenya Amendment Bill 2020. Number 20, the prayer for an order that Mr. Uhuru Muigai Kenyatta makes good public funds used in the unconstitutional constitutional change process promoted by the steering committee on the implementation of the Building Bridges to a United Kenya Task Force report established by Mr. Uhuru Muigai Kenyatta is declined for reasons that have been given. Number 21, the prayer for the orders that the Honorable Attorney General to ensure that other public officers who have directed or authorized the use of public funds in the unconstitutional constitutional change process promoted by the steering committee on the implementation of the Building Bridges to a United Kenya Task Force report make good the said funds is declined for the reasons that have been given. 22, the rest of the reliefs in the consolidated petitions not specifically granted are deemed to have been declined, and on course, this being a public interest matter, parties shall bear their own course. Those were the orders that were made by the High Court, from which the 4 appeals that I read earlier were raised. The IEBC, in its memorandum of appeal, raised 12 grounds of appeal, which I will summarize as hereunder, that the learned judges of the High Court erred in law in finding that the appellant lacks the requisite quorum for purposes of carrying out its constitutional and statutory mandate in relation to the intended appeal in the interpretation of the role of the appellant to verify that the initiative is supported by at least 1 million registered voters under Articles 257.4 of the Constitution and instead misconstrued the provision to mean verification of signatures. In finding that the provisions of Article 257(4) require a special framework for verification of signatures. In finding that the administrative measures put in place by the appellant to verify that the constitutional review initiative is supported by at least 1 million registered voters are invalid. The IEBC also faulted the learned judges for finding that the appellant ought to have carried out a nationwide voter registration exercise for the purpose of the intended referendum, for misconstruing the process of certification of the register of voters under Section 6 and 6A of the Elections Act with the requirements for continuous voter registration under Section 5 of the Elections Act, for finding that the appellant had an obligation to ensure that the promoters of the bill had complied with the requirements, public participation before transmitting the amendment bill to the county assemblies. And the IEBC further faulted the learned judges of the High Court for misapprehending the place of public participation in relation to constitutional review process by way of popular initiative, for failing to take note of its jurisdictional scope, for delivering a judgment that is internally incoherent, contradictory, and inconsistent, for granting orders which threatened the usurpation of the functional independence of the appellant, and for failing to appreciate that the evidential threshold for granting the declaratory reliefs had not been satisfied by the petitioners, and consequently arriving at the wrong conclusions. In Civil Appeal number 292 of 2021, this is the Building Bridges to United Kenya National Executive and another versus David D. and others. The two joint appellants, through Paul Mwangi and Company advocates, raised a total of 19 grounds. I'll just summarize a few of them. In summary, they faulted the learned judges for misapprehending the factual matrix relevant to the constitutional amendment initiative, for finding that the basic structure, eternity clauses, and unamendability doctrines are applicable under the Constitution of Kenya 2020, for introducing an extraneous, mandatory, and exclusive four-sequence process unknown under the Constitution of Kenya 2020, for imposing on the promoters of the amendment bill obligation to conduct nationwide public participation exercise prior to collection of signatures in support of the constitutional amendment initiative, for elevating the provisions of the Independent Electoral Boundaries Commission Act above Article 250 as read with Article 2 sub-Article 4 of the Constitution, and for misapprehending Article 257(4) and thereby unconstitutionally and unlawfully imposing a non-existent duty and or criteria for the verification of signatures. There are several other grounds that I will not read. In Civil Appeal number 293 of 2021, the Attorney General versus David D. and others, in his memorandum of appeal, the Attorney General raised 31 grounds, and I'll pick a few of them, that the learned judges of the High Court erred in law by finding that the basic structure doctrine applies to Kenya, for holding that the basic structure of the Constitution can only be amended through the exercise of the sovereign power of the people in the exercise of their primary constituent power, and not as contemplated under Articles 255, 256, and 257 of the Constitution, by finding that certain provisions of the Constitution are insulated from amendments and thereby classifying them as eternity clauses, by admitting and vividly relying on submissions of purported amicus curiae that were partisan, by holding that the amendment bill was not in tandem with an amendment of the Constitution, by popular initiative as provided under Article 257 of the Constitution, in misinterpreting the role of the President and the Executive in the process in the process leading to the amendment bill, in holding that the power to amend the Constitution through the popular initiative route is reserved for private citizens, by misinterpreting Article 257 with regard to the persons or entities that can promote amendments to the Constitution, and holding that the BBI National Secretariat could not promote a constitutional amendment, by holding that the BBI process was not in compliance with Articles 10 and 33 of the Constitution, and in failing to appreciate that the amendment bill was subjected to all processes and motions contemplated under Article 257 of the Constitution. Civil Appeal number E294 of 2021, Uhuru Muigai Kenyatta versus David Ndii and 82 others. The appellant, through Mr. Waweru Gatonyi and Company, raised 17 grounds of appeal, and I'll summarize some of them. He contended that the learned judges erred in law and violated or acted contrary to the rules of natural justice by making a decision adversely affecting the appellant and without hearing him, contrary to the provisions of Articles 27, 50, and 159 of the Constitution, by failing to find that the respondents, as petitioners in petition number E426 of 2020, having joined the appellant as a party to the petition, elected not to serve the said petition on the appellant, and further elected to abandon the suit or further proceedings against the appellant in the, I'll take that again. Having joined the appellant as a party to the petition, he elected not to serve the said petition on the appellant, and further elected to abandon the suit altogether. In finding that there was a preliminary issue to be determined as to whether the appellant could be sued in his personal capacity and not as the President of the Republic of Kenya, in spite of the fact that the appellant was not a party to the proceedings before the court at the election of the petitioners. In finding that the appellant neither entered appearance in the proceedings nor filed any grounds of objection or a replying affidavit, and in proceeding to hear and determine issues that had already been heard and determined by a competent court of concurrent jurisdiction in the matter of Third Way Alliance Kenya and another versus the head of the public service, Joseph Kinyua and 2 others, and Martin Kimani and 15 others in 2020 EKLR. The appellant further stated that the learned judges erred in making a declaration that he had contravened Chapter 6 of the Constitution by initiating and promoting constitutional amendment process under Article 257 by failing to by failing to appreciate the scope and extent of the constitutional doctrine of presidential immunity granted by Article 143 in light of the constitutional mandate and the obligations imposed on the office of the President by Articles 131 and 132 of the Constitution. In finding the appellant acting as the President of the Republic of Kenya can be sued in a civil court in his personal capacity during his tenure of office, and by failing to adopt a holistic and contextual interpretation of the constitutional provisions regarding the powers and exercise of presidential authority to meet our constitutional aspirations and values. There were also 3 cross appeals that were filed by the 15th respondent, that is the Kenya National Union of Nurses, the 72nd respondent, that is 254 Hope, and the 76th respondent, Mr. Omurara Omoke. The 15th respondent's cross appeal was premised on 6 grounds, and I'll briefly state them. A, that the learned judges of the High Court add in 1, ignoring, misapprehending, and misconstruing the doctrine of stare decisis and the stability of the common law. B, in failing to appreciate the petitioner's claim before the trial court on abuse of power, lack of public participation, and breach of legitimate expectation by the BBI task force as against the 15th respondent. C, in finding that the 15th respondent's petition for an independent health service commission was unmerited and could not be admitted for inclusion as a constitutional amendment. D, in failing to take judicial notice of the state of health care in the Republic of Kenya. E, in failing to consider and understand the claim before them and the written and oral arguments in support. F, in dismissing the claim before them after holding a contra review that the respondents in the petition had produced no evidence that there were contrary views to its proposals on constitutional amendments that were adopted in the first BBI report, and which recommendations were illegally left out of the Constitution Amendment Bill. The 72nd respondent, that is 254 Hope, raised 4 grounds of appeal, stating that the learned judges erred in failing to find that where the national executive or any of its task forces makes proposals, including legislative proposals and proposals to amend the Constitution, such proposals are subject to Article 47 of the Constitution. 2, in failing to find that the proposals to amend the Constitution for the failure to meet the threshold of rationality, justifiable reasons for the amendments connected to the stated purpose of the amendments and unreasonableness. 3, in ignoring that when the national executive or any government agency proposes to amend the Constitution, it is subject to a culture of justification through cogent and constitutionally sanctioned reasons in accordance with the Fair Administrative Actions Act. And lastly, in failing to find that there was a violation or at least a threatened violation of the prudent use of public resources, including human resources and funds, when the national executive initiated the amendments of the Constitution. The 76th respondent challenged parts of the decision of the High Court by raising the following grounds of appeal. A, that the learned judges erred in law by declining the prayer for an order that President Uhuru Kenyatta makes good public funds used in the unconstitutional constitutional change process promoted by him through the steering committee on the implementation of the Building Bridges to a United Kenya Task Force report, despite making the findings that he had no constitutional mandate to initiate constitutional amendment through popular initiative, and that he violated the provisions of Chapter 6 of the Constitution. B, by declining to order the Auditor General to establish the amount of public funds utilized in the promotion of the Constitution of Kenya Amendment Bill 2020. C, by declining to order President Uhuru Kenyatta, Honorable Raila Odinga, and the BBI Steering Committee to publish or cause to be published details of the budget and public funds allocated and utilized in promoting the impugned bill. D, by omitting to make a finding that the illegal authorization or use of public funds to initiate and promote the impugned bill by the President in the midst of the COVID-19 pandemic contravened Articles 10 and 201 of the Constitution. E, by omitting to take judicial notice of the huge amount of public funds, including a 4 billion car grant to MCAs who had assisted the President in promoting the Constitution amendment through the Building Bridges initiative, and that the surge in the incidence of COVID-19 associated with political rallies led by President Uhuru Kenyatta and the Honorable Raila Odinga to popularize the impugned bill has had an adverse effect on the people's right to the highest attainable standards of health, and that in view of the said issues, the prioritization of the constitutional amendments through the impugned bill was in violation of the state's obligations under Article 43 of the Constitution. F, by omitting to declare sections 32, 33, 37B, 39, 41, and 44 of the impugned bill unconstitutional. G, by declining to find and hold that the Parliament had no legal or constitutional capacity to debate and or approve the impugned bill in view of the advice of the Chief Justice, retired David Maraga, to President Uhuru Muigai Kenyatta to dissolve Parliament. And G, by relying on ongoing frivolous litigation as a basis for declining to order President Uhuru Muigai Kenyatta to dissolve Parliament in accordance with the advice of the Chief Justice, retired David Maraga. Thank you. I'll stop at that, and Justice Tuyot shall now begin to read a part of his judgment. I'll come back later.
Thank you, Mr. President. Good morning. I choose to read just two portions of my decision. I'll start with the question of the basic structure and its application to Kenya. The basic structure doctrine prescribes that notwithstanding the absence of explicit limitations on the constitutional amendment power, there are implied constitutional limitations which guard against amendments that change the basic structure of that interpretation is best, which makes the textual interpretation match the contextual. A history of the making of the current constitution gives color to the text of the provisions of Chapter 16 on amendments. After making significant strides towards the making of a new constitution, the Bomas initiative encountered a legal challenge presented in the Njoya and 6 others versus Attorney General and another. In those proceedings, the applicant inter alia sought a declaration that certain provisions of the Constitution of Kenya Review Act, which was the legal framework for the Bomas process, transferred, diluted, and vitiated the constituent power of the people of Kenya to adopt a new constitution.
Where the national executive or any of its task forces makes proposals, including legislative proposals and proposals to amend the Constitution, such proposals are subject to Article 47 of the Constitution. 2, in failing to find that the proposals to amend the Constitution for the failure to meet the threshold of rationality, justifiable reasons for the amendments connected to the stated purpose of the amendments and unreasonableness. 3, in ignoring that when the national executive or any government agency proposes to amend the Constitution, it is subject to a culture of justification through cogent and constitutionally sanctioned reasons in accordance with the Fair Administrative Actions Act. And lastly, in failing to find that there was a violation or at least a threatened violation of the prudent use of public resources, including human resources and funds, when the national executive initiated the amendments of the Constitution. The 76th respondent challenged parts of the decision of the High Court by raising the following grounds of appeal. A, that the learned judges erred in law by declining the prayer for an order that President Uhuru Kenyatta makes good public funds used in the unconstitutional constitutional change process promoted by him through the steering committee on the implementation of the Building Bridges to a United Kenya Task Force report, despite making the findings that he had no constitutional mandate to initiate constitutional amendment through popular initiative and that he violated the provisions of Chapter 6 of the Constitution. B, by declining to order the Auditor General to establish the amount of public funds utilized in the promotion of the Constitution of Kenya Amendment Bill 2020. C, by declining to order President Uhuru Kenyatta, Honorable Raila Odinga, and the BBI Steering Committee to publish or cause to be published budget and public funds allocated and utilized in promoting the impugned bill. D, by omitting to make a finding that the illegal authorization or use of public funds to initiate and promote the impugned bill by the President in the midst of the COVID-19 pandemic contravened Articles 10 and 201 of the Constitution. E, by omitting to take judicial notice of the huge amount of public funds, including a 4 billion car grant to MCAs who had assisted the President in promoting the Constitution amendment through the Building Bridges initiative, and that the surge in the incidence of COVID-19 associated with political rallies led by President Uhuru Kenyatta and the Honorable Raila Odinga to popularize the impugned bill has had an adverse effect on the people's right to the highest attainable standards of health, and that in view of the said issues, the prioritization of the constitutional amendments through the impugned bill was in violation of the state's obligations under Article 43 of the Constitution. F, by omitting to declare sections 32, 33, 37B, 39, 41, and 44 of the impugned bill unconstitutional. G, by declining to find and hold that the Parliament had no legal or constitutional capacity to debate and or approve the impugned bill in view of the advice of the Chief Justice, retired David Maraga, to President Uhuru Kenyatta to dissolve Parliament. And G, by relying on ongoing frivolous litigation as a basis for declining to order President Uhuru Kenyatta to dissolve Parliament in accordance with the advice of the Chief Justice, retired David Maraga. Thank you. I'll stop at that, and Justice Tuyot shall now begin to read a part of his judgment. I'll come back later.
Thank you, Mr. President. Good morning. I choose to read just two portions of my decision. I'll start with the question of the basic structure and its application to Kenya. The basic structure doctrine prescribes that notwithstanding the absence of explicit limitations on the constitutional amendment power, there are implied constitutional limitations which guard against amendments that change the basic structure of this new section entrenched a mechanism for replacement of the Constitution and expressly provided that the sovereign right to replace the existing Constitution with a new Constitution vested collectively in the people of Kenya and was exercisable by them through a referendum. For the first time, therefore, the constituent power of the people had found itself in the text of the Constitution. Against this backdrop, another referendum was conducted on the 4th of August 2010, giving birth to the Constitution of Kenya 2010. Admittedly, the new Constitution was created in the context where the constituent power of the people to replace their own Constitution had been codified in the Constitution that was to be replaced. What then are the lessons to draw from this journey? First, is that the 2005 and 2010 referendums are a testimony that the people of Kenya embraced and adopted a constitutional making concept in which the sovereign right to replace the Constitution vested in the people of Kenya, exercisable through a referendum. The exercise of constituent power in 2005 had received judicial nod in the decisions of Njoya and Onyango, while the 2010 referendum was codified through an amendment to the existing Constitution. The concept is therefore neither alien nor a foreign notion to Kenya. It is very much part of us. Second, and this is the second lesson, the 2005 experience tells us that the constituent power is unfettered and unlimited, notwithstanding that it is not textualized in the Constitution to be replaced. I therefore align to the view that while codifying the constituent power is good constitutional practice, failure to do so neither takes away.
Stand by then for the sequel to an epic.
You can go anywhere in the world, but no one feels football like we do.
And they sing, they dare to sing.
It's a rhythm.
1, 2. 1, 2.
Football.
La football.
Soccer.
1, 2.
Textualizing it, though a bonus, is superfluous and unnecessary. And this is an invaluable part of the context of the history of our constitution making offers. Let me now turn to the text, because I must compare the text and the context. In doing so, it has to be remembered that, as correctly pointed out by the Attorney General, Njoya was decided against the backdrop of making of a new constitution altogether. Should it be any different in circumstances not involving the replacement of the constitution, but in regard to its amendment? The respondents to this question invite this court to approach it from the perspective that the basic structure doctrine protects the Constitution against constitutional dismemberment and replacement disguised as amendments. I start by noting that the provisions of Chapter 16 makes reference to the word amendment of the Constitution. Neither in the chapter nor elsewhere in the Constitution is the word amendment defined. And the Interpretation and General Provisions Act, Chapter 2, is not helpful because by dint of Section 2, the provisions of that statute do not apply in or to the construction or interpretation of the Constitution. Turning elsewhere, Black's Law Dictionary, the 10th edition, defines amendment as follows: a formal and usually minor revision or addition proposed, made to a statute, constitution, pleading, order, or other instrument. This can then be contrasted with what a repeal or abrogation is. A repeal is abrogation of an existing law by express legislative act. Express repeal is repeal by specified declaration in a new statute or main motion. Abrogation is the abolition or repeal of a law, custom, institution, and the like. Now, to be inferred from these definitions is that unless otherwise expressed by a constitution itself, an amendment entails a minor revision, alteration, or addition to the Constitution, but which nevertheless does not destroy the Constitution being amended. It does not extend to abrogation, complete repeal, or replacement of the Constitution. In this regard is the work of Richard Albert in his text, Constitutional Amendments, Breaking and Changing Constitution, where he makes a distinction between amendment and dismemberment. He takes a view that constitutional dismemberments are transformative changes with consequences far greater than amendments. They do violence to the existing constitution, whether by remaking the constitution's identity, repealing or reworking the fundamental right, or destroying and rebuilding a central structure pillar of the constitution. A constitutional dismemberment can both enhance or weaken democracy depending on what in the existing constitution is dismembered. It is incompatible with the existing framework of the Constitution because it seeks to achieve a conflicting purpose. So in truth, the purpose and effect of constitutional dismemberments are the same as to unmake a constitution. So for example, in our context, an amendment to transfer judicial authority from the judiciary and independent tribunals to the executive is to unmake the Constitution as it fundamentally alters a central feature of the Constitution. An amendment is not as drastic because properly defined, it keeps the altered Constitution in unison with its pre-change identity, rights, and structure. I then refer to Article 255(1). Now, it does seem to me that the provisions of Article 255(1) simply provide for an amendment. Anything that goes further than an amendment must be sanctioned by the exercise of primary constituent power. The provisions of Article 255(1) and the popular initiative were made against the backdrop that the making and unmaking of the Constitution is a preserve of the people exercising their primary constituent power. A change that derogates from the core character of the Constitution is not a change in unity with the Constitution, but one that defaces it. That change too is one that can only be made by the people organized in and exercising their primary constituent power. By falling short of making provisions and procedure for unmaking or repeal or reenactment or abrogation of the Constitution, a textual reading of Article 255(1), in my view, matches or is in accord with the contextual interpretation of the clause that the people to make such change, that the power to make such change rests elsewhere in the primary constituent power of the people and need not be codified. Let me then turn on what constitutes basic structure of our Constitution. This is what the High Court rendered itself. And I read, while the basic structure cannot be altered, I think I'll skip that, but just emphasize that there was a controversy on their finding that whether a particular clause in a constitution consists of an amendable clause or not will be fact-intensive determination to be made after due analysis of the Constitution. That is what I turn to interrogate. The appellants criticize the findings and argue that the High Court failed to identify the said clauses and provide any objective criteria for such identification. It is submitted that in the absence of clarity, no amendment could be effected without first seeking the court's interpretation, clarification, and concurrence on which provisions are amendable. Thus, therefore, this therefore will be left to the subjective opinions of the individual judges. A common thread running through the Bomas draft constitution, the WACO draft constitution, the revised harmonized draft, and the proposed draft constitution is the provision for amendment of the Constitution by popular initiative. The rationale for this amendment process, captured in the final report of the recommendations by the CKRC report, as regards the issue of constitutional supremacy, was that the new Constitution should have some entrenched provisions which Parliament would have power to amend without first seeking the views of the people at referendum. Under the scheme of the various constitutional proposals, a distinction was drawn between entrenched and non-entrenched provisions of the Constitution. The entrenched provisions are those that the people felt were the core values and provisions of the Constitution and therefore needed to be barricaded by a special amendment mechanism in which the seal of approval by people exercising their constituent power was mandatory.
Welcome to a world of instant coffee, instant toast, even instant popcorn. Now, for the first time ever, get
Kenya, the sovereignty of the people, the principles and values of the Republic, the Bills of Rights, the term of the office of the President, the independence of the judiciary and constitutional commissions, the functions of Parliament, the values and principles of devolution, and the provisions of the amending chapter. The WACO draft retained the same list, save for a small change in regard to the devolution. The entrenched provisions in the latter draft and the revised harmonized draft are almost forward those in the Bomas and WACO drafts. They again found their way into the protective provisions of Article 255(1) of the 2010 Constitution. It is a list that survived changes made in the various draft constitution. It is testimony that the people meant what they said and were clear as to what they considered to be the essential features of the Constitution. It is a list to be revered and cannot be shortened or lengthened by judicial interpretation or craft. It matters not that in the mind of a judge, the list is either too limiting or too extensive. To be deduced is that if the people of Kenya felt so strongly that the provisions relating to the matters listed in Clause 255(1) needed protection from indiscriminate amendment, then even more so, those are the very provisions which should not be abrogated or replaced without the exercise of the people's constituent power. In my view, what comprises the basic structure of the Constitution is therefore specifically defined by the people of Kenya, and there are those in Article 255(1) which even in amendment require the exercise of constituent power, and that is this secondary power, constituent power. That said, the true concept of the basic structure in the Kenyan Constitution becomes clearer still by looking more closely at the words of Article 255(1). They require compliance of Article 257 for an amendment that relates to the matters listed in Article 255(1). Save for reference to Chapter 16 and Articles 10, the articles of the Constitution to be protected are not specifically set out. Instead, they are identified by theme. And this makes a difference. What comprises the basic structure is what is in respect to those thematic matters. So, for example, matters on the sovereignty of the people, which power, by dint of Article 3, is delegated to the three distinct arms of government, extends the protection to the doctrine of separation of power. So, while the doctrine of separation of power is not directly mentioned in Article 255(1), it is part of the basic structure of our Constitution, as it is a subset of the wider design on how the Constitution has organized and structured the exercise of sovereign power. I take a view that what comprises the basic structure of our Constitution is therefore easily identifiable. But should a need for judicial inquiry arise as to whether a matter is part of the basic structure of our Constitution, then that inquiry will not be rudderless, neither will it be an unguided exercise, because it is firmly beaconed in Article 255(1). So those are my short views on the question of the basic structure and its breadth. I then turn to the question of the IEBC quorum. In deference to Section 8 of the IEBC Act, the second schedule to the Act makes provisions as to the conduct of the business and affairs of the Commission. The schedule underwent some amendments through Act number 1 of 2017. In respect to the quorum of the Commission, the amendment reduced it from 5 to 3 in the following words: the quorum for the conduct of the business at the meeting of the Commission shall be at least half of the existing members of the Commission, provided that the quorum shall not be less than 3 members. The amendment was not without controversy and was the subject of a constitutional challenge in Katiba Institute and 3 others versus the Attorney General. In a decision rendered on the 6th of April 2018, Mwita J declared the new provision unconstitutional. In the impugned judgment, the High Court judges proceed on the assumption that the latter provision requiring a quorum of not less than 5 was the existing provision. The judges do so without ambiguity in paragraph 702 of their decision, which I have set out. The argument by IEBC is that while the decision in Katiba had the effect of declaring the new paragraph 5 of the second schedule unconstitutional, the decision did not revive the older provision, and so as it now stands, there is no statutory provision on the quorum of the Commission. What would be the legal effect of the above declaration? Cited by IEBC is the decision of the Supreme Court in Mary Wambui versus Gishuki Kingara, in which the court had occasion to consider the effect of a court's declaration of invalidity of a statute or provision within it. I have set out what the Supreme Court said. Clearly, the true effect of such a declaration can only be gleaned from the declaration itself. The court may make the declaration retrospective from the date of enactment of the offending provisions or statute. The court may choose to limit the retrospective effect of such declaration or even to suspend it to a future date. And as held by the Supreme Court in Mary Wambui, whether the effect ought to be retroactive and or proactive depends on a case-to-case basis. So, for example, in petition number 413 of 2016, Boniface Oduor versus the Attorney General, the High Court, after declaring sections 33B1 and 33B2 of the Banking Act to be constitutional, suspended the declaration for 12 months from the date of the decision. Where, however, a declaration by the court is silent as to when it shall take effect, the date of the declaration is deemed to be the date of effect. In Katiba Institute, Justice Mwita declared paragraph 5 of the second schedule, amongst other provisions, to be constitutionally invalid without more. The judge neither limited the retrospective effect of the declaration nor suspended it. To be inferred, therefore, is that the declaration operated retrospectively to the date of the enactment of the provision. The repercussion of the declaration was that the amendment of paragraph 5 of the second schedule to the Act, which was introduced by the Elections Laws Amendment Act number 34 of 27, was constitutionally void. Under the Interpretation and General Provisions Act, to amend means to repeal, revoke, rescind, cancel, replace, add to or vary, or the doing of any two or more of those things simultaneously on the same written law or instrument. Amendment of a statute is a legislative act, and while it is open to a court to declare an amendment to be constitutionally void, the declaration does not revive the former provision, just as it does not repeal or annul a provision it has declared to be constitutionally invalid. The former provision would have to be revived by legislation, a preserve of the lawmaking body. And in this regard, I have quoted a Supreme Court decision from India. And although not having a direct bearing to the matter at hand, one would perhaps draw parallels from Section 20 of the Interpretation and General Provisions Act. So, in my view, revival of a previous provision of statute.
The grand reopening of Italian football.
You can go anywhere in the world, but nobody feels football like we do.
And they sing, they dare to sing.
It's a rhythm.
Take an instance where a declaration of an invalidity of an amendment by the High Court is not challenged on appeal. If it were to be construed that the court's pronouncement amounts to automatically reviving the amended provision, then even courts of a higher rank will be bound by that revival, notwithstanding that such a court would be of a view that the declaration was made per incuriam. This is because the declaration will have removed the amendment from statute. If, however, it is taken that the High Court declaration is simply a pronouncement that the amendment is in conflict with the Constitution and therefore void and inapplicable to the rights of the parties before it, then a court of coordinate or higher jurisdiction is free to arrive at a different decision in another matter because the amendment will still exist in statute. This latter position is perhaps the better position in a jurisdiction like ours, where there is no requirement that every declaration of unconstitutionality of a statute or provision must be tested and affirmed by the apex court. Given my appreciation of the law, I'll reach an outcome that although the effect of the decision in Katiba Institute and another was to render the new provisions of paragraph 5 to be ineffective and a nullity, the decision did not revive the former provisions. The argument that the High Court relied on an existing provision of statute is therefore, in my view, with some merit. Yet, as I shall be proposing in due course, in interrogating the question of quorum of IEBC, the trial court was obliged to reach an outcome that was aligned to the expectations of both the Constitution and the IEBC Act. Simply, the court was not handicapped in resolving the matter because the Constitution, read in conjunction with the IEBC Act, provides a clear answer to the question. Next is whether the decision of the High Court in Isaac v. Watt in regard to the issue of quorum was a decision in rem, and if so, whether the High Court was bound by it. The court in Isaiah v. Watt was not called upon to declare the composition of IEBC illegal or unconstitutional as a result of the resignation of 4 of its commissioners. Was not only called, let me take that again, the court in Isaiah v. Watt was not only called upon to declare that the composition of IEBC was illegal and unconstitutional as a result of the resignation of 4 of its members, but also invited to declare that as composed at that time, IEBC lacked quorum to conduct or carry out the business. You would be familiar with that decision. IEBC is a constitutional commission established under Article 88 of the Constitution. The pronouncement by the court in Isaiah v. Watt as to the constitutionality of its composition and quorum was without doubt a pronouncement made in public law and a judgment in rem in regard to the 2 issues. And I identify with the holding in Ems versus Queen that if a formal declaration of invalidity of administrative regulation is not considered effective towards all those who are subject to it, it may mean that to all other persons concerned with the application of the regulation, including subordinate administrative agencies, have to keep on giving effect to what has been declared a nullity. It is obvious for the purpose of avoiding this undesirable consequence that in municipal law, the quashing of a bylaw is held to be in rem. I close the quotes. So one would be sympathetic if IEBC were, on the strength of the Isaiah v. Watt decision, take comfort as to its quorum. Yet for now, the more decisive issue is whether the pronouncement in rem could bind a court of coordinate jurisdiction. Stated more boldly is the question, is the stare decisis doctrine to be suspended when a judgment is in rem so that the precedent binds a court of equal rank? I do not consider this to be a matter of small importance, not in the least because of the passionate argument by counsel for IEBC that inconsistency of pronouncement of courts in areas of public law confuses members of the public as to what the law is and is a recipe for judicial anarchy and mayhem in public law. Fortunately, other jurisdictions have had to grapple with similar predicament. Faced with the question whether a court was bound to follow the declaration of unconstitutionality of a statute by another court of coordinate jurisdiction is a view taken by a judge in Canada in the case of R versus Sullivan, which I will invite you to read and which I have quoted. This is what I draw from that decision. The importance of having consistency in the application of the law, particularly in matters touching on the public, cannot be minimized. Both the public and persons or bodies charged with carrying out public functions should be able to tell without difficulty or hesitation whether their actions or conduct passes legal or constitutional muster. To hold that a public body is properly and legally constituted today and to say otherwise the next day may not be good for public administration. So there is much to be gained in legal stability. There is much to be gained in the legal stability that is brought by the stare decisis doctrine. Yet, that has to be put on a scale against the effect of foreclosing another court of coordinate rank from relooking at the same question in a different matter where forceful arguments are made as to the correctness of the earlier decision. Not to allow a revisit would be to stifle judicial debate in an area that may well be unsettled, and in the process to stunt the growth of jurisprudence. It may well be to allow a matter that has been wrongly decided to take root and to perpetuate itself. So as to strike a balance, the doctrine of stare decisis, even in public law, should not apply any different, but a latter court should be reluctant to open a matter already pronounced in rem by a court of coordinate jurisdiction unless there is compelling reason to believe that the outcome is different. In addition, I suggest the Attorney General or the public body affected, if not parties, should always be invited to express themselves on the matter before the court renders itself, so that the matter can have the full benefit of arguments on the subject. Lastly, if the earlier decision is on appeal, then the latter court should await the decision, the outcome of the appeal. Let me now return to the circumstances of the decision of Isaiah B. Watt. And this was not challenged, and I have therefore to examine whether the High Court was justified in departing from it. I have set out that IEBC is established by Article 88(1). It is a commission to which Chapter 15 of the Constitution applies. The Constitution does not require enactment of legislation to fix the exact composition of Chapter 15 commissions. However, Article 88 of the Constitution provides as follows in respect to the IEBC. The Commission shall exercise its powers and perform its functions in accordance with this Constitution and national legislation. I would take it that this provision gives national legislation sufficient latitude to fix the number of members of the Commission as long as it is within the range that is provided in Article 251 of the Constitution, and also to fix its quorum for purposes of effectively discharging its mandate. In its preamble, the IEBC Act declares itself to be an act of Parliament to make provision for the appointment and effective operation of IEBC and for connected purposes. Subsection 1 ordains the Commission shall consist of a chairperson. This is subsection 1 of Section 6, that the Commission shall consist of a chairperson and 6 other members appointed in accordance with Article 254 of the Constitution and the provisions of the Act. While the Constitution does not fix the exact composition of IEBC and only provides a range of not less than 3 and not more than 9, statute fixes the composition to be 7. None of the parties suggest that national statute on the composition of IEBC is unconstitutional. And insofar as it does not breach the constitutional range, there will be little merit in an argument that Section 5(1) abridges the Constitution. The statutory composition of IEBC is therefore 7. And as to why Parliament settled on 7, the High Court suggested the Constitution placed the minimum number of the commissioners of the Independent Commission at 3 and the highest number at 9. Parliament, while appreciating the important mandate the IEBC discharges, picked a high number of 7 commissioners to constitute and placed its quorum at 5 members. Close quotes. That is a view I endorse. IEBC gallantly pressed the position that a quorum should be examined against the constitutional contemplation that the composition of the Commission should be 3, could be 3, and if so, the number of commissioners, and if the number of commissioners had fallen to 3, as had at the time material to the petition, then a quorum of 3 met the threshold. I'm afraid I'm unable to agree with the argument by IEBC. Whilst the statute has fixed 7 as the membership of IEBC, it contemplated that death, resignation, or other reasons could cause the actual membership to fall below the statutory number. Given the important constitutional mandate of IEBC, which includes conducting by-elections and referendum, whose timing is unpredictable, the IEBC Act has a robust mechanism for promptly filling of any vacancies. And I've quoted Section 7 of the Act. These provisions speak to the urgency in which the recruitment process must be commenced and completed. Paragraphs 1, 3, and 4 of the first schedule to the statute, which elaborates on the procedure for appointment of the chairperson and members, gives short timelines as a restatement of the speed within which the vacancies must be filled. I have set out those provisions. The scheme of the statute and the regulations is that by providing for prompt mechanism for filling vacancies, then at all times and as much as possible, IEBC should be in its full complement of members. A recognition that given its important constitutional mandate, IEBC should carry out its functions with all hands on deck. To allow the quorum of the Commission to oscillate with the actual number of members at any time would be to countenance a possibility that for as long as the numbers do not fall below 3, then the appointing authority need not promptly or at all trigger the process of filling the vacancies. The membership of IEBC could then suffer want of gender parity or regional or ethnic diversity that is required by Article 254. Drastically reduced membership could lead to a crunch in confidence by members of the public as to the Commission's ability to be independent and truly neutral. The quorum question must therefore be answered against this broader constitution and statutory imperative. And it yields an easy answer, that the quorum of IEBC must be seen against the full composition of 7 required by the IEBC Act. And so I'm aligned with the rationale of the decision of Justice Mwita and Katiba Institute. In conclusion, on that question, the effect of the decision was to sustain the quorum at 5 or at least 4. To hold that the quorum could be anything less than half of the membership of 7 is to weaken the Commission. It is common ground that IEBC formulated administrative procedures to guide on the verification of signatures in support of a constitutional amendment, There can be little doubt that formulation of such guidelines will be the business of the Commission, given the critical importance of that threshold in a popular initiative process, and the Commission needed to be quorate. So following a slightly different route, I reached the same decision as the High Court, that IEBC was not quorate when it embarked on the business of verifying the BBI signatures on membership of only 3. So thank you. I'll invite the parties and counsel to read the rest of my decision. Thank you, Mr. President.
Thank you, my brother Justice Tuyot. The Honorable Justice Zichale will now read another part.
Thank you, Mr. President.
Sorry, my sister.
Yes.
I realize it is just about 11, and we had indicated that we'll adjourn, take a short health break at 11. I propose instead of my sister starting and then we have to adjourn in between, We take a short health break now, and we turn, and then the Honorable Lady Justice.
Of a constitutional amendment. There can be little doubt that formulation of such guidelines will be the business of the Commission, given the critical importance of that threshold in a popular initiative process, and the Commission needed to be quorate. So following a slightly different route, I reached the same decision as the High Court, that IBC was not quorate when it embarked on the business of verifying the BBI signatures on membership of only 3. So thank you. I'll invite the parties and counsel to read the rest of my decision. Thank you, Mr. President.
Thank you, my brother Justice Tuyot. The Honorable Justice Charlie will now read another part.
Thank you, Mr. President.
Sorry, my sister.
Yes.
I realize it is just about 11, and we had indicated that we'll adjourn, take a short health break at 11. I propose instead of my sister starting, and then we have to adjourn in between. We take a short health break now, and we turn, and then the Honorable Lady Justice Ichale will read our judgment. Thank you.
importance, not in the least because of the passionate argument by counsel for IEBC that inconsistency of pronouncement of courts in areas of public law confuses members of the public as to what the law is and is a recipe for judicial anarchy and mayhem in public law. Fortunately, other jurisdictions have had to grapple with similar predicament. Faced with the question whether a court was bound to follow the declaration of unconstitutionality of a statute by another court of coordinate jurisdiction is a view taken by a judge in Canada in the case of R versus Sullivan, which I will invite you to read and which I have quoted. This is what I draw from that decision. The importance of having consistency in the application of the law, particularly in matters touching on the public, cannot be minimized. Both the public and persons or bodies charged with carrying out public functions should be able to tell without difficulty or hesitation whether their actions or conduct passes legal or constitutional muster. To hold that a public body is properly and legally constituted today and to say otherwise the next day may not be good for public administration. So there is much to be gained in legal stability. There is much to be gained in the legal stability that is brought by the stare decisis doctrine. Yet, that has to be put on a scale against the effect of foreclosing another court of coordinate rank from relooking at the same question in a different matter where forceful arguments are made as to the correctness of the earlier decision. Not to allow a revisit would be to stifle judicial debate in an area that may well be unsettled, and in the process to stunt the growth of jurisprudence. It may well be to allow a matter that has been wrongly decided to take root and to perpetuate itself. So as to strike a balance, the doctrine of stare decisis, even in public law, should not apply any different, but a latter court should be reluctant to open a matter already pronounced in rem by a court of coordinate jurisdiction unless there is compelling reason to believe that the outcome is different. In addition, I suggest the Attorney General or the public body affected, if not parties, should always be invited to express themselves on the matter before the court renders itself, so that the matter can have the full benefit of arguments on the subject. Lastly, if the earlier decision is on appeal, then the latter court should await the decision, the outcome of the appeal. Let me now return to the circumstances of the decision of Isaiah B. Watt. And this was not challenged, and I have therefore to examine whether the High Court was justified in departing from it. I have set out that IBC is established by Article 88(1). It is a commission to which Chapter 15 of the Constitution applies. The Constitution does not require enactment of legislation to fix the exact composition of Chapter 15 commissions. However, Article 88 of the Constitution provides as follows in respect to the IEBC. The Commission shall exercise its powers and perform its functions in accordance with this Constitution and national legislation. I would take it that this provision gives national legislation sufficient latitude to fix the number of members of the Commission, as long as it is within the range that is provided in Article 251 of the Constitution, and also to fix its quorum for purposes of effectively discharging its mandate. In its preamble, the IBC Act declares itself to be an act of Parliament to make provision for the appointment and effective operation of IBC and for connected purposes. Subsection 1 ordains the Commission shall consist of a chairperson. This is subsection 1 of Section 6, that the Commission shall consist of a chairperson and 6 other members appointed in accordance with Article 254 of the Constitution and the provisions of the Act. While the Constitution does not fix the exact composition of IBC and only provides a range of not less than 3 and not more than 9, statute fixes the composition to be 7. None of the parties suggest that national statute on the composition of IEBC is unconstitutional. And insofar as it does not breach the constitutional range, there will be little merit in an argument that Section 5.1 abridges the Constitution. The statutory composition of IEBC is therefore 7. And as to why Parliament settled on 7, the High Court suggested the Constitution placed the minimum number of the commissioners of the Independent Commission at 3 and the highest number at 9. Parliament, while appreciating the important mandate the IEBC discharges, picked a high number of 7 commissioners to constitute and placed its quorum at 5 members. Close quotes. That is a view I endorse. IEBC gallantly pressed the position that a quorum should be examined against the constitutional contemplation that the composition of the commission should be 3, could be 3, and if so, the number of commissioners, and if the number of commissioners had fallen to 3, as had at the time material to the petition, then a quorum of 3 met the threshold. I'm afraid I'm unable to agree with the argument by IEBC. Whilst the statute has fixed 7 as the membership of IEBC, it contemplated that death, resignation, or other reasons could cause the actual membership to fall below the statutory number. Given the important constitutional mandate of IEBC, which includes conducting by-elections and referendum, whose timing is unpredictable, the IEBC Act has a robust mechanism for promptly filling of any vacancies. And I've quoted Section 7 of the Act. These provisions speak to the urgency in which the recruitment process must be commenced and completed. Paragraphs 1, 3, and 4 of the first schedule to the statute, which elaborates on the procedure for appointment of the chairperson and members, gives short timelines as a restatement of the speed within which the vacancies must be filled. I have set out those provisions. The scheme of the statute and the regulations is that by providing for prompt mechanism for filling vacancies, then at all times and as much as possible, IEBC should be in its full complement of members. A recognition that given its important constitutional mandate, IEBC should carry out its functions with all hands on deck. To allow the quorum of the Commission to oscillate with the actual number of members at any time would be to countenance a possibility that for as long as the numbers do not fall below 3, then the appointing authority need not promptly or at all trigger the process of filling the vacancies. The membership of IEBC could then suffer want of gender parity or regional or ethnic diversity that is required by Article 254. Drastically reduced membership could lead to a crunch in confidence by members of the public as to the Commission's ability to be independent and truly neutral. The quorum question must therefore be answered against this broader constitution and statutory imperative. And it yields an easy answer, that the quorum of IEBC must be seen against the full composition of 7 required by the IEBC Act. And so I'm aligned with the rationale of the decision of Justice Muita and Katiba Institute. In conclusion, on that question, the effect of the decision was to sustain the quorum at 5 or at least 4. To hold that the quorum could be anything less than half of the membership of 7 is to weaken the Commission. It is common ground that IEBC formulated administrative procedures to guide on the verification of signatures in support of a constitutional amendment, There can be little doubt that formulation of such guidelines will be the business of the Commission, given the critical importance of that threshold in a popular initiative process, and the Commission needed to be correct. So following a slightly different route, I reached the same decision as the High Court that IBC was not quorate when it embarked on the business of verifying the BBI signatures on membership of only 3. So thank you. I'll invite the parties and counsel to read the rest of my decision. Thank you, Mr. President.
Thank you, my brother Justice Tuyot. The Honorable Justice Zichale will now read another part.
Thank you, Mr. President.
Sorry, my sister.
Yes.
I realize it is just about 11, and we had indicated that we'll adjourn, take a short health break at 11. I propose instead of my sister starting and then we have to adjourn in between, we take a short health break now and we turn, and then the Honorable Lady Justice Ichale will read our judgment. Thank you. With paragraph 5 of the second schedule to the Act for purposes of carrying out its business relating to the conduct of the proposed referendum, including the verification of signatures in support of the Constitution of Kenya Amendment Bill under Article 257(4) of the Constitution submitted by the Building Bridges Secretariat. Number 11, a declaration is hereby made that at the time of the launch of the Constitution of Kenya Amendment Bill 2020 and the collection of endorsement signatures, there was no legislation governing to govern the collection, presentation, and the verification of signatures and the conduct of referenda in the circumstances of this case renders the attempt to amend the Constitution of Kenya through the Constitution of Kenya Amendment Bill 2020 flawed. Number 13, a declaration is hereby made that county assemblies and parliament cannot, as part of their constitutional mandate, to consider a Constitution of Kenya Amendment Bill initiated through a popular initiative under Article 257 of the Constitution, change the contents of such a bill. Number 14, a declaration be and is hereby made that the second schedule to the Constitution of Kenya Amendment Bill 2020 is so far as it proposed to predetermine the allocation of 70 constituencies is unconstitutional. Number 15, a declaration be and is hereby made that the second schedule to the Constitution of Kenya Amendment Bill 2020, insofar as it proposed to direct the Independent Electoral and Boundaries Commission on its function of constituency delimitation, is unconstitutional. Number 16, A declaration be and is hereby made that the second schedule to the Constitution of Kenya Amendment Bill 2020 is so far as it proposed to have determined by delimitation the number of constituencies and apportionment within the counties is unconstitutional for want of public participation. Number 17, a declaration is hereby made that administrative procedures for the verification of signatures in support of constitutional amendment referendum made by the Independent Electoral and Boundaries Authority and in violation of Article 94 of the Constitution and Sections 5, 6, and 11 of the Statutory Instruments Act 2013. Number 18, a declaration is hereby made that Article 257.10 of the Constitution requires all the specific proposed amendments to the Constitution be submitted as separate and distinct referendum questions to the people. Number 19, a permanent injunction be and is hereby issued restraining the Independent Electoral and Boundaries Commission from undertaking any processes required under Article 257.4 and 5 in respect of the Constitution of Kenya Amendment Bill 2020. Number 20, the prayer for an order that Mr. Uhuru Muigai Kenyatta makes good public funds used in the unconstitutional constitutional change process promoted by the steering committee on the implementation of the Building Bridges to a United Kenya Task Force report established by Mr. Uhuru Muigai Kenyatta is declined for reasons that have been given. Number 21, the prayer for the orders that the Honorable Attorney General to ensure that other public officers who have directed or authorized the use of public funds in the unconstitutional constitutional change process promoted by the steering committee on the implementation of the Building Bridges to a United Kenya Task Force report make good the said funds is declined for the reasons that have been given. 22, the rest of the reliefs in the consolidated petitions not specifically granted are deemed to have been declined, and on course, this being a public interest matter, parties shall best
reconcile contradictions, draftsmanship gaps, vagueness, and phraseology in the Constitution and arrive at the conclusion that the basic structure doctrine is applicable in Kenya for the safety of the 2010 Constitution. In support of their contention, they relied on several authorities which I have set out in my judgment, and in the interest of time, I shall not go through all of them. But the ones that I brought on board into my judgment include in the matter of the Speaker of the Senate and another, Mother Kerubo Moracha versus University of Nairobi, in the Commission for the Implementation of the Constitution versus the National Assembly, where Lenaola J, as he then was, held that where the basic structure or design and architecture of our Constitution are under threat, the court can genuinely intervene and protect the Constitution, end of quote. They also relied on the decision of Jasbir Singh Rai, and as I've said, they also relied on scholarly works, in particular the works of Professor Dietrich Conrad, writing on implied limitations. In support of the contention that the Constitution also has the unspoken language, they placed reliance on scholarly writings of Yaniv Rosnai in unconstitutional constitutional amendments, the limits of amendment powers, where he states, and I quote, "In order to find an amendable basic principles, one has to resort to interpretation of the Constitution as a coherent whole. It is, after all, a constitution and not just a disjointed collection of constitutional pieces which must be interpreted. According to this approach, the language of the Constitution is not merely the explicit one, but also the implicit one." The respondents opposed to the appeal argued that notwithstanding the fact that the 2010 Constitution does not expressly bar amendments, it does so implicitly, as one has to pay attention to its overarching themes and/or the spirit of the Constitution. Heavy reliance was also placed on the Indian Supreme Court decision of Kesavananda, and in this Kesavananda decision, by a majority of 7-6, it was held that there are some provision in the Indian Constitution that form the basic structure of a constitution and hence are not amendable, not even when the prescribed procedures are adhered to. On the other hand, the appellants and the respondents in support of the appeal were clear. The basic structure doctrine is not applicable in Kenya. They urged us to find that the 2010 Constitution has sufficient safeguards that militate against hyper-amendments of yesteryears. The appellants and the respondents supporting the appeal also sought to rely on case law, decided cases, the history, text, and context of the 2010 Constitution. These included in the Council of Governors versus the Attorney General, where the Supreme Court stated as follows: courts may not impose a meaning that the text is not reasonably capable of bearing. In other words, interpretation should not be unduly strained. It should avoid excessive peering at the language to be interpreted, end of quote. On the invocation of the spirit of the Constitution, reliance was placed on a decision of South Africa in the decision of the Premier of KwaZulu-Natal versus the President of South Africa, where the Constitutional Court held that, and I quote, "The reliance upon the spirit of the Constitution is, in my view, misconceived. There is a procedure which is prescribed." In particular, I wish to read some part of the decision in the matter of Paul K. Semogerere and others versus the AG. This is a decision from Uganda wherein they discounted the Kesavananda decision, and this is what they said. Those who frame the Constitution also know that new and unforeseen problems may emerge. That problems once considered important may lose their importance because priorities have changed. The solutions to problems once considered right and inevitable are shown to be wrong or to require considerable modification. That judicial interpretation may rob certain provisions of their intended effect. That public opinion may shift from one philosophy of government to another. The framers of the Constitution did not put any limitations on the amending power because the end of a Constitution is the safety, the greatness, and the well-being of the people. Changes in the Constitution serve these great ends and carry out the real purpose of the Constitution. There is also the other decision from Uganda, Male, Mabarizi, and others, which, of course, also discounted the doctrine of basic structure. So, in my view, the above decisions from Malaysia, Singapore, Zambia, Uganda, and Tanzania demonstrate that the courts have rejected the doctrine of basic structure on the reasoning that a constitution, being a living document, must inevitably change as society progresses. That a living constitution must be flexible to allow for a country's growth, and the review of a constitution is essential so as to cater for new and unforeseen future problems, and hence it is inadvisable to have a constitution cast in stone. To my mind, I have no illusion whatsoever that the Kenya's constitutional past was indeed a dark past. The pre-2010 constitution was misused and abused for selfish political gains. Several instances stand out. He was found guilty of an election offense, and by operations of the law was barred from running in the ensuing by-election. To save him, His Excellency, the late President Kenyatta, passed into law a bill tabled in Parliament and passed into law in a single afternoon, pardoning Honorable Paul Gay of an election offense. Then there was the 1982 constitutional amendment that dealt a death blow to multi-party democracy and turned Kenya into a de jure single-party state of the then all-powerful Kenya African National Union. The reason for the hastily carried out amendments or dismemberments of the pre-2010 Constitution are not difficult to discern. The power to amend the Constitution was provided in Section 47 of the pre-2010 Constitution, and this power was reposed solely in Parliament to the exclusion of the proverbial Wanjiku. I have cited the provisions of Section 47 of the 2010 Constitution. Our pre-2010 Constitution, like the Indian Constitution, did not bar amendability. It is against the backdrop of the Indian Constitution, where there is no provision for amendment of the Constitution by the constituent power, but the power to amend being reposed solely in Parliament, that the Casavananda decision was made. In his scholarly writings, Yaniv Rosnai traces the history of the basic structure doctrine and how it was developed in response to Prime Minister Indira Gandhi's attempt to amend the Constitution. He states, "The Indian Constitution lacks any unamendable provisions. Also, Indian jurisprudence, rooted in British tradition, initially rejected the notion of implicit unamendability. That position, however, was revised in the 1960s and 1970s following Prime Minister Indira Gandhi's far-reaching attempts to amend the Constitution, leading eventually to the judicial development of the basic structure doctrine. According to this doctrine, the amendment power is not unlimited. Rather, it does not include the power to abrogate or change the identity of the Constitution or its basic structure," end of quotes. Yaniv Rosnai provides a further criticism of the Kesavananda case for failure to identify the unamendable clauses. He writes, "The Kesavananda case did not provide a precise list of unamendable features that constituted the Constitution's basic structure, thus forming a sort of common law doctrine that develops on a case-by-case basis." And he further stated that the Kesavananda judgment created a constitutional quicksand. In his written submissions, Professor Charles Manga Foreman, an amicus curiae on the basic structure doctrine, outlines the essence of this, what he refers to as the much acclaimed Indian basic structure. And he states, "The much acclaimed Indian basic structure doctrine owes its origin to the famous Supreme Court decision in Kesavananda decision, although the issue had been raised in a number of earlier cases. According to this doctrine, even in the absence of explicit limitation on constitutional amendment powers, Parliament's amendment powers are not unlimited. There are, as a result, implied constitutional limitations that render an amendment unconstitutional if it infringes, negates, or substitutes the basic structure of the Constitution, regardless of whether all the formal or procedural requirements of amendment have been met." End of quote. Professor Foreman points out that when the doctrine of basic structure was developed, India was dealing with, and I quote, "India's 20th century independence constitution of the 1950s, whereas African courts are now dealing with made-in-Africa constitutions of the 21st century," end of quote. And that due to the changed circumstances, the Kesavananda decision is not relevant to our circumstances. This court has had occasion to express its reservations in adopting foreign concepts to our homegrown constitution. And I cite the case of Kenya Airports Authority versus Mitubel Welfare Society, where this court stated as follows: "Whereas citation and reliance on persuasive foreign jurisprudence is valuable, foreign experiences, values, and aspirations of other countries should rarely be invoked in interpreting the Kenyan Constitution. the progressive needs of the Kenyan Constitution are different from those of other countries. In my view, the position obtaining in India, insofar as it related to its constitution, was not any different from the position obtaining in Kenya before the promulgation of the 2010 Constitution on 27th of August 2010. The Indian Parliament has the exclusive power to amend the Constitution. Our Parliament has similar power to amend the Constitution prior to the 2010 Constitution. The situation obtaining in Kenya after the promulgation of the 2010 Constitution is different. There are explicit provisions on the amendments of the Constitution, as well as inbuilt mechanisms which limit Parliament in amending the Constitution. The methodology to amend the entrenched provisions is also clearly spelled out. There are also clearly spelled out entrenched provisions. Suffice to state that the Constitution itself anticipated that it can be amended, and it provided for its own amendment procedures. In the same Constitution, there are strictures as regard entrenched provisions which require a referendum and which ones do not. These are listed in Article 255, 1, Subarticle A to J, and I shall not go through them. The High Court, in the impugned judgment, appreciated as much, and at part of paragraph 473 of its judgment, it stated, "To be sure, there is no clause in the Constitution that explicitly makes any article in the Constitution unamendable. However, the scheme of the Constitution, coupled with its history, structure, and nature, creates an ineluctable and unmistakable conclusion that the power to amend the Constitution is substantively limited. The structure and history of this Constitution makes it plain that it was the desire of Kenyans to barricade it against destruction by political and other elites. As has been said before, the Kenyan Constitution was one in which the Kenyans bequeathed themselves in spite of and at times against the political and other elites. Kenyans therefore were keen to ensure that their bequests to themselves would not be abrogated through either incompatible interpretation, technical subterfuge, or by the power of amendment unleashed by stealth." End of quote. In my view, whereas the High Court correctly found that there are no explicit provisions in the 2010 Constitution barring amendments, the judges erred in finding that the bar to amendment is implicit. As stated above, the pre-2010 Constitution did not have provision for the amendment of the Constitution by way of a popular initiative, and neither did Parliament recognize the notion of implicit unamendability. Indeed, the issue in Joya and others versus the Attorney General was whether the Parliament could, in the exercise of its amendment power under Section 47 of the Constitution, repeal the Constitution. I have cited a passage from that decision of Joya decision that is relevant to this judgment. It is the Joya decision that paved the way for the amendment of the pre-2010 Constitution by constituent power via a referendum. This was in recognition of the supremacy of the sovereignty of the people, who then exercised that sovereignty in the referendum that birthed the 2010 Constitution. In my view, the Joya decision was our Kesavananda moment, and to paraphrase Yaniv Rosnai, this may have been as a result of the late President Kenyatta's and the late President Moi's far-reaching attempts to amend the Constitution, and there was need to curb those excesses. As history will attest, the clamor for a new constitution was long and arduous. But that notwithstanding, when the Kenyan people finally bequeathed themselves with a new constitution, they ensured that it would be free from hyper amendments. Indeed, the 2010 Constitution was informed by Kenya's dark past, and its citizenry were determined never again shall we have a constitution that can be amended at will. In the formulation of the 2010 Constitution, a conscious effort was made to ensure that we do not have hyper amendments. This conclusion is supported by findings contained in the final report of the Constitution of Kenya Review Commission, CKRC, which mirror Chapter 16 of our Constitution. I've reproduced part of the reports of CKRC that mirror Chapter 16 of our Constitution. Following the recommendations of CKRC and true to word, Chapter 16 of the 2010 Constitution is dedicated to amendment of the Constitution. In my view, the clear text and language of Chapter 16 is that there are explicit provisions in the 2010 Constitution providing for amendment, and therefore there is no reason to look outside the Constitution and import the basic structure doctrine on the basis that the Constitution has the unspoken language and or implicit provisions. And it has now been slightly more than 10 years since the Constitution was promulgated, and to the credit of the drafters of the Constitution, the 21 attempts to amend the Constitution, 19 were through a parliamentary initiative, whilst 2 were through a popular initiative, have all fallen by the wayside. These 21 attempts are tabulated in the written submissions of Mr. Ogeto, the Solicitor General appearing for the Honorable Attorney General. I have also reproduced those 21 attempts in part of this, my judgment. It is also true that the framers of our Constitution balance between flexibility and rigidity. To this end, CKRC had recommended, and I quote, that there is need to protect the Constitution against indiscriminate amendments. If the amendment procedure is too simple, it reduces public confidence in the Constitution. The converse, however, is also true. If the amendment procedure is too rigid, it may encourage revolutionary measures to bring about change instead of using the acceptable constitutional means. Thus, a balance must be struck between these two extremes, end of quotes. Accordingly, a balance had to be struck to avert violent revolutions against abusive amendments. In an article, The Politics of Constitutional Change in Kenya Since Independence, 1963 to 1969, Professor Okoth Ogendo underscores the fate of post-independence constitutions. He writes, constitutional systems in Anglophone Africa have not had a happy history, especially during the last decade. Almost without exception, the independence documents have either ended up in military dustbins or have undergone change so profound and rapid as to alter their value, content, and significance beyond recognizance, end of quote. I hear the good professor saying the Independence Constitution was so badly dismembered, and that if they did not suffer the fate of dismemberment, it was more likely that the Constitution would find their way into dustbins following military coups. The writings of Professor Okoth Ogendo echo the profound words of John F. Kennedy in 1962 when he stated, and I quote, "Those who make peaceful revolution impossible will make violent revolution inevitable," end of quote. It is no secret that the framers of our 2010 Constitution struck a balance between stability and instability by providing for amendments in Chapter 16 of the 2010 Constitution, and this being the supreme law of the land, it was desirable to give it a more stable character and free it from hyper amendments. This is important as no society is static, and what is good for one generation may not necessarily be good for the next. In an article entitled "No Generation Has the Right to Impose Its Own Values and Political Principles on a Later Generation" by Professor Foreman, he cites another scholar, Colvin De Silva, who states as follows: "Constitutions are made in terms of the stage of development at which any given society or country has arrived. In terms of that stage of development, it looks upon things and for any generation of people to imagine that it can so completely project itself into infinity of the future, so as to be able to decide its own generation that it will constrain a future generation or generations forever within the confines of its own postulates, is to make a mistake of thinking that any human collectivity is the equivalent of the divinity. End of quote. He concludes, it is unlikely that the framers of the new or revised African constitutions wanted to prevent future generations from repealing these constitutions. A constituent body is omnipotent only to the extent that it has no power to destroy or limit the omnipotence of a future constituent body. In short, the present and future generations should not be ruled by the dead hand of their ancestors. End of quote. I think it behooves us to recognize that in spite of the supremacy of constitutions, we cannot and should never legislate from the graves, what Professor Forman refers to as the dead hand. We cannot possibly shackle future generations but by what we consider to be noble today. The other troubling aspect of the impugned judgment is that the High Court came to the conclusion that whatever is amendable will be decided on a case-by-case basis. And this is what they said. Whether a particular clause in the Constitution consists of an amendable clause or not will be fact-intensive determination to be made after due analysis of the Constitution, its foundational structure, its text, its internal coherence, the history of the clause and the constitutional history, and other non-legal considerations permitted by our canon of constitutional interpretation principles. End of quote. The above finding, in my view, poses difficult questions. Who is to carry out the fact-intensive determination? And at what stage in the process of constitutional change? The appellants told us, and rightly so in my view, that in terms of seeking an advisory opinion, Wanjiku has no place, as by dint of Article 163, Sub-Article 6, this is a preserve of the national government, a state organ, or a county government. I reproduce therein the provision of that article. Since Wanjiku does not have the luxury of approaching the Supreme Court under Article 163, Sub-Article 6, how does Wanjiku get to have an issue subjected to fact-intensive determination? Sight should also not be lost that judges, being human, are not infallible, and they should not arrogate unto themselves the unfettered power to validate or invalidate amendments on the basis that they are eternal causes from their preferred reading of the Constitution. If for a moment we were to find that judges are fallible, where will be the unwritten constraint? The absence of constraint, no doubt, leads to uncertainty and absurdity. In an article by Adan Kasia Abebe entitled The Substantive Validity of a Constitutional Amendment in South Africa, appearing in a South African journal, I'll just read part of what he said in that article. The idea of a judicially enforceable implied limits on the power of constitutional amendment is particularly unacceptable in cases where a constitution explicitly outlines the fundamental principles and subjects such principles to amendment, as is the case in South Africa. In the absence of a clearly defined and enforceable substantive limits, the judicial control of constitutional amendments will lead to a situation where courts effectively arrogate the role of the people and their elected representatives in defining a polity's fundamental values over which there may be a reasonable disagreement. The absence of clearly defined limits also means that every constitutional judge will have his or her own list of what is basic and what is not. The judicial power to define basic social and political values belies the ideal that courts should merely apply settled rules and principles and not discover some vague fundamental values to invalidate the best judgments of the overwhelming majority of the political representative. In the absence of clearly established substantive limits and an explicit jurisdiction to enforce substantive limits on constitutional amendments, the power and responsibility of ensuring compliance with any desirable substantive limits lies beyond the courtroom. Only the democratic process or a revolution could legitimately and effectively stymie any attempt to legitimize undemocratic behavior through constitutional amendments, end of quote. Similar sentiments on infallibility of judges are expressed in an article entitled "The Conundrum of Unconstitutional Constitutional Amendments" by Paul Jen Yap, and he states, "The people may not always be right, for popular sovereignty is not an absolute guarantee of substantive justice. But neither, in these circumstances, the judiciary must cede to the expression of popular sovereignty, not merely because the amendment is an unmistakable expression of public will, but because this convergence of interests is undisputable evidence of the triumph of the political process over the intervening institutional and electoral barriers erected by the separation of governmental powers," end of quote. In my view, it is not correct to elevate judges to the status of demigods, and just as it is possible to have a distrustful and rogue parliament, it is also possible to have a rogue and distrustful judiciary, more so bearing in mind that the latter are not elected as the people's representative. I know that as Kenyans, we love to demonize our elected political leaders. We do this all the time, but rarely do we stop to remember we get the leaders we deserve. I'm therefore of the persuasion that the contest of what is amendable and what is not should not be left to be a matter of judicial innovation. Judges, just like parliamentarians, cannot assume supremacy over all others, as indeed it is the people who are sovereign. Article 1, Sub-Article 1 of the 2010 Constitution screams out, "All sovereign power belongs to the people of Kenya and shall be exercised in accordance with this Constitution," end of quote. The people of Kenya, in the exercise of their constituent power in a referendum, voted for the amendment of the pre-2010 Constitution. In came the 2010 Constitution with provisions on how it can be amended in accordance with this Constitution. On the ultimate expression of the will of people, I find an article by Yaniv Rosnai Unconstitutional, and allow me to read this passage. He says, Constitutional amendment seems puzzling. The Constitution is the highest positive legal norm. The power to amend the Constitution presupposes the same kind of power as the one to constitute a Constitution. It is a supreme power within the legal system, and as such, it can reach every rule or principle of the legal system. If this power is indeed supreme, how can it limit itself? If it is limited, how can it be supreme? This is the legal equivalent of the paradox of omnipotence. Can an omnipotent entity bind itself? Both positive and negative answers to these questions lead to the conclusion that it is not omnipotent. Moreover, if the amendment power is a kind of constituent power, then it remains unclear why a prior manifestation of that power prevails over the later exercise of a similar power. Quite the reverse, according to the principle, a later norm should prevail over a conflicting earlier norm of the same normative status. Finally, the Constitution, which expresses the people's sovereign power, binds and guides ordinary law, which expresses the Parliament's ordinary power. The common meaning of unconstitutionality is that an ordinary law, inferior to and bound by the Constitution, violates it. How can unconstitutionality refer to an act carrying the same normative status as the Constitution itself? The question posed by Yaniv Rosnai is, the question that he has posed, why a prior manifestation of that power prevails over the latter exercise of a similar power, underscores the people's will to amend the Constitution without a prior manifestation of that power prevailing over the subsequent exercise of a similar power. Suffice to state that in the 2010 constitutions, Kenyans recognize their constitutional right to amend the Constitution as long as this is done in the manner provided in the Constitution. If perchance the framers of our Constitution had intended that there be a limitation on the power of amendment, they would have provided as much. There are no such limitations in Chapter 16 of the Constitution. And at the risk of being repetitive, I reiterate there is no clause in the 2010 Constitution that prohibits amendments, but there is an inbuilt mechanism that provides safeguards, and I'm of the persuasion that the High Court erred in imposing another hurdle on the basis of an implied provision anchored on the spirit or overarching theme of the Constitution. In my view, the High Court erred in invoking the spirit of the Constitution without the need to do so, given the clear and ambiguous language of the 2010 Constitution on amendments. It is also my view, as explained above, that the findings of the High Court were not supported by the context, structure, and history of the Constitution 2010. The upshot of the above analysis is that the appellant's appeal on the non-applicability of the basic structure is for allowing. However, this is subject to the majority decision of this court. So much as relates to the issue of the basic structure. The next, I shall then proceed now to look at the role of the President, the role of His Excellency the President in the BBI process. I think for a start, for me, the beginning point is Article 131(2)(c) of the Constitution, which requires the President to promote and enhance the unity of the nation. And with the noble intention, on 9th of March 2018, His Excellency the President, Uhuru Muigai Kenyatta, held talks with the former Prime Minister Raila Odinga that culminated in what is now commonly referred to as a handshake. The intention of the handshake was to bring to an end the political disharmony, demonstration process, and disgruntlements that arose with the outcome of the presidential elections held in August 2017. The handshake would then become a political tool to calm the nation that was deeply divided and to allow for consensus building. I think the history about the formation of the task force, as well as the formation of the steering committee, were well captured in the introductory part of this judgment that was done by the President of the Court. And I will not repeat that. But suffice to state that it is not in dispute that the Task Force on Building Bridges to Unity Advisory Task Force was appointed by His Excellency on 24th of May 2018, and subsequently this gave way to the steering committee, and that the process leading up to the formulation of the Constitution of Kenya Amendment Bill 2010, in my view, was largely driven by the executive, as it is difficult to truncate the BBI task force and the BBI steering committee from the submissions of the letter by Honorable Junet Mohammed and Honorable Waweru as promoters of the Constitution of Kenya Amendment Bill 2020. It is clear that one thing led to the other until the culmination of Mohammed and Waweru and Honorable Waweru to the IEBC seeking approval of the format to be used in the collection of signatures. Article 256 and 257 of the Constitution provide for amendments by way of a parliamentary initiative and not a popular initiative. The proposals by Honorable Junet and Honorable Waweru would best have been channeled through a parliamentary process as they were heavily laden with the executive arm. The route of popular initiative was not open to them as this was not a Wanjiku-driven process. There was an alternative argument that although His Excellency the President Uhuru Kenyatta, was not a promoter of the Constitution of Kenya Amendment Bill, it was contended that nothing stops him from being a promoter of a popular initiative in his own personal capacity, as it may well be possible that a president may find himself in a peculiar position that she does not enjoy the support of Parliament, hence he would be locked out of both the parliamentary as well as the popular initiative. Mr. Kiragu Kimani, Senior Counsel, while urging the appeal on behalf of His Excellency, submitted that the President under Article 38 of the Constitution of Kenya has a right to make political choices just like any other Kenyan, and that the term initiator that was used by the High Court in reference to His Excellency the President was not recognized in the Constitution, and that there was nothing that barred the President from being a promoter of the bill, that the President has a right to campaign for any political party or cause. Further, that Article 12 of the Constitution provides that every citizen is entitled to the rights, privileges, and benefits of citizenship, subject to the limits provided or permitted by this Constitution, end of quote. It was contended that if we were to find that His Excellency the President in his personal capacity cannot use the route of a popular initiative, then this would be tantamount to denying him his rights as a citizen. In my view, the balancing of the rights of a sitting president poses a challenge, as it is difficult to make a demarcation when a president is acting in his personal capacity vis-a-vis his official capacity. Can a president cease to be a president without handing over power during the tenure of his office? In the circumstances of this case, we were told that His Excellency Honorable Uhuru Kenyatta was not the promoter. Indeed, the High Court acknowledged that His Excellency the President was not the promoter, and they coined the term initiator, a term not anywhere in the constitutional amendment process. Be that as it may, the question to be answered is whether His Excellency the President can be a promoter of an amendment bill. In my view, I would liken the situation to that obtaining in the military, where military personnel are often said to be children of a lesser god, to the extent that some of their fundamental rights are limited by virtue of their joining the military. Regrettably, by conduct, there are limitations placed on public officers as to what they can do and what they cannot do. I liken the position of His Excellency the President to that of a judge, where one is a judge 24/7, and it is difficult to say when he or she is not acting in his official capacity. Given the above, it is my humble view that His Excellency the President cannot therefore be a Wanjiku for the purposes of Article 257 of the Constitution, and to this extent I'm in agreement with the High Court findings that His Excellency the President cannot initiate changes to the Constitution through a popular initiative as provided in Article 257. The third item that I will go into is the issue of the legality of the BBI Task Force and the BBI Steering Committee. As to the issue of the legality of the BBI Task Force and the Steering Committee, and as explained above, the Task Force and the Steering Committee were born out of noble intentions of His Excellency the President. Both were ad hoc committees appointed by His Excellency the President for purposes of advising him on the discharge of his constitutional mandate in fostering unity in the nation. The question of illegality of the BBI Task Force had actually come for consideration before Mativo J, who had considered this issue and had come to the conclusion that His Excellency the President acted within his powers under Article 131 and 132 of the Constitution. This was in the case of Third Way Alliance. I've also had the advantage of reading the draft judgment of my sister, Okwengu J.A., and I'm in agreement with the sentiments expressed therein that the BBI Task Force and the BBI Steering Committee were not illegal outfits. On the issue of the presidential immunity, I shall not take much time on this, save to agree with what the High Court said, that when it comes to civil proceedings, the president is not insulated if he does anything or fails to do anything in his own personal capacity. Then there is the issue of the quorum of IEBC. On the question of quorum of IEBC, the appellants and the respondents in support of the appeal challenged the High Court findings that the IEBC was not correct for purposes of its business, including the verification of signatures in support of the Constitution of Kenya Amendment Bill 2020. For a start, the IEBC is an independent constitutional commission established pursuant to Chapter 15 of the 2010 Constitution. Article 250, Sub-Article 1 sets out the composition of an independent commission. It reads, each commission shall consist of at least 3, but not more than 9 members. On the other hand, Section 5 of the IEBC Act provides that the commission shall consist of a chairperson and 8 other members appointed in accordance with Article 250, Sub-Article 50 of the Constitution and the provision of this Act. What I would like to say as regards this issue, or my finding, is that the IEBC, as currently constituted with 3 members, cannot be said not to be constitutionally compliant. And the question that I ask myself, if with 3 members, the commission is constitutionally compliant, and it can continue to operate because it is constitutionally compliant, in circumstances like those, can one really say that for purposes of carrying out its deliberations, the members of a quorum in a meeting must be 5? In my view, I think the constitutional provisions take precedence, and if the commission, as currently constituted is constitutionally compliant, it can carry out its mandate with the 3 members of the commission. I think it would be absurd to say that it must have, for it to be correct, there must be 5 members. I've also made comments on the 2 cases of Biwott, as well as the case decided by Mwita, as well as the one that was decided by Okwany. But additionally, it is my considered view that the issue of verification of signatures is not a matter requiring a policy decision. The functions of IEBC are spelled out in Section 4 of the Act, and they are numerous. In my respective view, the verification of signatures is not a matter that arises out of the resolution or decisions made by the commissioners at a meeting of the commission, but one dictated by the operation of the law, as the process of verification of signatures is not a policy decision to require the IEBC to be correct. In my view, it cannot be said that in performing such mundane tasks as the continuous education of voters would require the Commission to be correct, more so bearing in mind that the Commission has a secretariat that undertakes its day-to-day operations. I am therefore of the considered opinion that the verification of signatures was not null and void for lack of quorum. and neither was it a function that required a policy decision. Then there was the question of the role of IEBC in a popular initiative. In paragraph 733 of the impugned judgment, the High Court found that the IEBC's role include verification of signatures and not mere ascertainment of numbers of registered voters whose signatures accompany the popular initiative bill. It would follow that the IEBC would need some legal or regulatory framework to guide it in its operation. On the other hand, if the IEBC role is the venial administrative task of ascertaining numbers, then perchance no further legal or regulatory framework would be required. The court proceeded to define what verification is, and this is what they said. The only reasonable meaning of the term verify, as used in Article 257(4) of the Constitution, includes both the ascertainment of numbers and confirming the authenticity of the signature submitted. The role of IEBC is spelled out in Article 257 of the Constitution. In the matter before us, we were told that the IEBC carried out verification by removing names that did not have signatures. They also removed names that did not have the national identity cards or passport numbers. They removed duplicated numbers and asked the promoters to depone affidavits, to have affidavits deponing that the signatures were collected with the consent of the parties. I have in this judgment reproduced a format of the collection of signatures that was submitted by Honorable Junet Mohammed and Honorable Waweru to IEBC, and it was approved. And that format captured the following details. One had to include their name, their ID or passport number, their county, their constituency, their county assembly ward, the polling station, their mobile numbers, their email address, and then they also had to sign or to thumbprint. Article 257, Sub-Article 4 did not, in my view, envisage a forensic examination on the authenticity of the signatures, more so bearing in mind that IEBC does not have a repository of signatures. But even if it had, in my view, it would be a Herculean task to undertake. For instance, the verification would require that IEBC obtains non-signatures of those who appended their signatures to the initiative. The non-signatures would then be subjected to forensic investigation by handwriting experts. Given that the IEBC published the list of those said to have supported the initiative, what was so difficult for one to say that they did not append their signatures? In my view, to place near impossible demands on IEBC would, as it were, greatly cripple the operations of IEBC. On the question of continuous voter registration, the High Court found that there had been no evidence that the IEBC had sensitized citizens that there was continuous voter registration. It is this finding that led to Declaration Number 9 in their judgment, wherein the court declared that the Constitution of Kenya Amendment Bill cannot be subjected to a referendum before the IEBC carries out nationwide voter registration exercise. Mr. Morara Omoke, the 76th respondent, urged us inter alia that the IEBC could not conduct a referendum before conducting nationwide voter registration, as this would disenfranchise many voters. The IEBC, on the other hand, argued that it had been continually conducting voter registration at the constituency level. Article 88, Sub-Article 4 requires IEBC to undertake continuous registration of citizens as voters. Suffice to state that this is an ongoing process, and it is upon every Kenyan who attains the age of 18 to register as a voter. It is the same registered voters who vote in an election that also vote in a referendum. Indeed, the 1 million persons who support an initiative are registered voters. Further, there is a distinction between the time and place of an election vis-à-vis the time and place of a referendum in the 2010 Constitution provides for an election cycle. We know that elections are carried out after every 5 years. Not so when it comes to a referendum, as there is no defined time when a referendum is to be held. In my view, the fact that IEBC carries out continuous voter registration, it cannot be said that they fail to carry out nationwide voter registration when we know that the time and place of a referendum, unlike an election, is not known and cannot be defined with specificity. Then on the question of creation of new constitution, as regards the issue of creation of 70 new constituencies, in Declaration number 14, the High Court held that the Constitution of Kenya Amendment Bill is unconstitutional insofar as it proposed to predetermine the allocation of 70 more constituencies. It held it is unconstitutional for a Constitution of Kenya Amendment Bill to directly allocate and apportion constituencies in contravention of Article 89 of the Constitution. Indeed, that provision was in Clause 10 of the Amendment Bill. Article 89, Sub-Article 1 of the 2010 Constitution provides that there shall be 290 constituencies for the purposes of the election of members of the National Assembly provided in Article 97(1)(a). The respondents opposed to the appeal contested this part of the bill on the basis that it sought to amend Article 89(1) of the 2010 Constitution. Firstly, it is important to say that the High Court held that Article 89, Sub-Article 1 of the 2010 Constitution is not what they were calling an eternity clause, and they said that it is amenable to amendments subject to due process being followed. They stated as much at paragraph 670 of the judgment. I shall not go over it. It is clear that the court recognized, and rightly so in my view, that Article 89(1) of the 2010 Constitution is amenable to amendment. Having so recognized, was it unconstitutional for the Constitution of Kenya Amendment Bill to purport to create 70 more constituencies? In my view, once we appreciate that Wanjiku can seek to amend any provisions of the Constitution as long as the procedure set out in Articles 255 to 259 of the Constitution is adhered to, then the Kenyan people have the right to reduce or increase the number of constituencies to ensure that there is no underrepresentation. They can even vary the mandate of IEBC. Further, the functions of IEBC are spelled out in Section 4 of the Act, include delimitation of constituencies and wards in accordance with this Constitution. Black's Law Dictionary defines delimitation as the act of making a boundary or fixing a limit. Suffice to state that the Constitution of Kenya Amendment Bill 2020 did not seek to make boundaries or fix the limits of a boundary, but increase in the number of constituencies. The allocation of increased constituencies is not, in my view, delimitation. And clearly, the IEBC has no role to play in the creation of constituencies. And the upshot of the above analysis is that the second schedule to the Constitution of Kenya Amendment Bill 2020 in seeking to determine the creation of 70 more constituencies, in my view, not unconstitutional. We shall then look at the IEBC regulatory framework, and I will not go into great details on this, but suffice to state that the Constitution, the IEBC Act, the Elections Act make provision as regards the conduct of a referendum. and it is my pursuant to the Constitution, the Independent Electoral and Boundaries Commission Act and the Elections Act to govern the collection, presentation, and verification of signatures, and a legal framework to govern the conduct of a referenda. Indeed, the High Court appreciated as much when at paragraph 783 of the judgment, they stated as follows, and I quote, "Notwithstanding the absence of an enabling legislation as regards the constitutional expectation, values, principles, and objects, especially those in Article 10 of the Constitution, are met," end of quote. Besides, in the titles Alila and two others versus the Attorney General, the High Court had held, and I quote, "Secondly, I find that the Constitution has already set up a proper legislative framework for holding a referendum." And the court further stated, that is the High Court, further, there are explicit provisions in the Elections Act which govern the conduct of referendum in Kenya, end of quote. In the impugned judgment, the court had endorsed the findings in the Alila decision. At paragraph 603 of the judgment, it stated, "Though we have found that it is necessary to enact Referendum Act, we do not subscribe to the school of thought that absence of legislation implementing a provision of the Constitution renders such a provision inoperative and unenforceable. On that finding, we agree with the decision in titles Alila and two others." And at paragraph 6 of 6, the court stated, "It is, however, our view, and we hold that notwithstanding the absence of an enabling process may still be undertaken as long as the constitutional expectation, values, principles, and objects are met," end of quote. In my view, it is surprising that having found so, the High Court proceeded to make a declaration to the effect that a declaration is hereby, this is what they said, "A declaration is hereby made that the absence of legislation or legal framework to govern the collection, presentation, and verification of signatures and the conduct of referenda in the circumstances of this case renders the attempt to amend the Constitution of Kenya through the Constitution of Kenya Amendment Bill 2020 flawed," end of quote. In my view, it is my view that the IEBC existing statutory framework as well as the administrative procedures established therein was sufficient for purposes of carrying out a referendum. However, I am alive to the fact that there are two referendum bills that are pending before Parliament. It is my considered opinion that notwithstanding the fact that these bills have not been passed and fully debated by Parliament, Notby says that there was no regulatory framework to govern the conduct of a referenda. Consequently, it is my finding that there is legal framework to govern the collection, presentation, and verification of signatures, as well as the conduct of referenda. The other aspect is the issue of whether His Excellency, the President, at no point was the High Court told that shown any return of service or affidavit of service in respect of service upon His Excellency. What Mr. Olechwer had said is that he had used an email address, and although Mr. Olechwer had said he sued him in his personal capacity, that address seemed not to have been a personal address. But even notwithstanding that, it was imperative upon the court, once it came to the conclusion that the Attorney General was entitled to equality and freedom from discrimination as per the dictates of Article 27(1) of the Constitution, which provides for equality and freedom from discrimination. And then there is also Article 25(c), which provides for a fair trial as a fundamental right. In my view, the right to be heard is enshrined in the 2010 Constitution, and no one can be deprived of this right. This court has underscored the right to be heard in the decision of Onyango Olo versus the Attorney General when it held that the principle of natural justice applies where ordinary people reasonably expect those making decisions which will affect others to act fairly, and they cannot act fairly and be seen to have acted fairly without giving an opportunity to be heard. A decision in breach of the rules of natural justice is not cured by holding that the decision would otherwise have been right, since if the principle of natural justice is violated, it matters not that the same decision would have been arrived at. Denial of the right to be heard renders any decision made null and void ab initio. In my view, it matters not that His Excellency Honorable Uhuru Muigai Kenyatta is the President of the Republic of Kenya. He is entitled to the protection of the law, as the law protects the weak as well as the strong. It was wrong for the High Court to have proceeded with the hearing and thereafter make adverse findings against His Excellency Honorable Uhuru Kenyatta without ascertaining whether he had been served, either with the petition and or the subsequent hearing notice or hearing notices. With regard to issues raised by Mr. Morara Omoke, whether the bill violated Article 43(1)(a) of the Constitution in view of the COVID-19 pandemic, whether both or either of the houses of Parliament were infirmed from considering the constitutional amendment bill in view of the Chief Justice's advisory opinion for the dissolution of Parliament, and whether the petitioners had made out a case for disclosure and publication of the BBI Steering Committee's financial information. I've had the advantage of reading the lead judgment by Musinga J.A., the President of the Court, on these issues, and I entirely agree with him. I've made a few comments, but in the interest of time, I will not go through those comments. And on the appeal by the Kenya National Union of Nurses, the 15th respondent herein, the gist of their complaint was that whereas their views had initially been included in the BBI task force, the same did not find its way to the Constitution of Kenya Amendment Bill 2020. They supported the appeal and urged us to find that the amendment process was legal and constitutionally sound, and faulted the High Court for finding that the basic structure doctrine applied in Kenya. As stated above, the 15th respondent's grievance is that their views, whereas their views of having an independent commission were initially captured in the BBI task force, these views were subsequently omitted. In my view, this is a fairly straightforward issue. If the 15th respondent would like an amendment of the 2010 Constitution to have itself included as an independent commission, they can take advantage of the provisions of Article 257 of the Constitution. They cannot ride on an initiative of another and complain that their views have been left out. In any event, the fact that their views were contained in the BBI task force did not create any legitimate expectation on their part. I shall say no more on this issue, save to state that the appeal is devoid of merit and it is accordingly dismissed. Those are my views. Thank you.
Thank you, my sister, Justice Sichale. We will now have my brother, the Honorable Mr. Justice Gatembu, summarize his judgment.
Thank you. Thank you very much, President. I think at the conclusion of the arguments, last time we sat here, you told us that when we retire, we can consider your submissions and other material. Now, I think it is my turn to say that when you retire, you can read our judgments in full. So I'll give you just a short synopsis of what I have said in my judgment. So this is what I have said. In this judgment, I only address some of the issues arising from the consolidated appeals. I do so under 6 broad themes. The first is the question of applicability of the basic structure doctrine to Kenya. Second is the question of the scope of popular initiative under Article 257. The amendment process used in this instance, the BBI process, is constitutional. The third area I will address is in relation to IBC, its role in the popular initiative process, whether there is adequate legal infrastructure to enable IBC to conduct the referendum under 257 of the Constitution, whether IEBC's administrative procedures are adequate to enable it to undertake its verification role, whether it had quorum to conduct business in that regard, and whether it is under a duty to conduct nationwide question of whether a single or multiple questions should be framed for the referendum. The fourth area is in relation to matters concerning the President. Does the President enjoy absolute immunity from civil proceedings under Article 143 of the Constitution? And the fifth area I will touch on is on the amicus curiae, whether the High Court was wrong in admitting them in the proceedings. And sixth is the question whether the High Court wrongly exercised jurisdiction in the matter by reason of doctrines of mootness and ripeness, political questions and constitutional avoidance, and deference to other state organs. So I begin with the basic structure doctrine, and I reproduce there, and I will not read what the High Court said. I then look at the arguments from both sides, and then I say this. In terms of identification of the basic structure in the Constitution, as provided in the preamble, the 18 chapters and the 6 schedules of the Constitution, which form the fundamental core structure, values, and principles of the Constitution, which cannot be amended without recalling primary constituent power of the people. Judiciary, Parliament, the executive, the independent commissions, and other offices, and the devolved system of government, and includes the provisions on land and environment, leadership and integrity, public finance, and national security. I then reproduce there at length what they say. To illustrate the distinction between unamendable and amendable constitutional provisions, the court cited Article 2(1) of the Constitution, which provides that the Constitution is the supreme law of the Republic and binds all persons and all state organs at both levels of government, as an example of an amendable or eternity clause, which can only be changed through exercise of primary constituent power on the ground that it expresses a core and fundamental principle of the Constitution. In contrast, the court stated Article 2, sub 5 of the Constitution, which provides that the general rules of international law shall form part of the law of Kenya, is also part of the basic structure, and that the spirit or the core meaning or value of that clause cannot be changed without involving the primary constituent power. It may, however, be amended through the secondary constituent power under Article 255 to clarify its meaning. The other example given is Article 89(1) of the Constitution, which provides that there shall be 290 constituencies, in respect of which the court expressed that its core meaning and import can only be changed through primary constituent power, but the actual number of constituencies can be increased or reduced through either secondary constituent power or constituted power. I then set out the arguments that have been made on either side on applicability of the doctrine, and then I go on to say as follows. Having considered those arguments, the question whether the High Court correctly determined that the doctrine of basic structure is applicable in Kenya is a difficult one. The arguments advanced by learned counsel on both sides are powerful and most persuasive. The following, however, is the view I take. In his book, Constitutional and Administrative Law, D. Smith argues that although written constitutions differ widely in their purposes, form, and content, they will normally be found to have two characteristics in common. Namely, there will be the fundamental law of the land, and there will be a kind of higher law and the legal source of legitimate authority. A higher kind of law in that the law set out in the Constitution will be hierarchically superior to other laws and will not be alterable except by a specially prescribed procedure for amendment. Chapter 16 of the Constitution, titled Amendment of this Constitution, prescribes the procedure for amendment of the Constitution. Article 255(1) stipulates that a proposed amendment to the Constitution shall be enacted in accordance with Article 256 or 257 and approved in accordance with Clause 2 by a referendum. If the amendment relates to the matters that are set out under that article, which I then reproduce. Article 256 sets out the amendment process through a parliamentary initiative, while 257 sets out the amendment process by popular initiative. On the face of it, those provisions of Chapter 16 of the Constitution would appear clear and unambiguous, and construed in the natural and ordinary sense would mean that every provision in the Constitution is amendable, provided the stipulated process of amendment is followed. However, Article 259 of the Constitution commands that the Constitution shall be interpreted in a manner that promotes its purposes, values, and principles, advances the rule of law and human rights and fundamental freedoms in the Bill of Rights, permits the development of the law, and contributes to good governance. Article 10 of the Constitution commands that in applying or interpreting the Constitution or any law, the national values and principles of governance set out in that article, including the rule of law, democracy, and participation of the people, bind all organs, state officers, and all persons. Earlier, the same principle of constitutional interpretation was expressed by the Court of Appeal in Tanzania in the Dianabo case, and I have reproduced portions of that. I have also cited the Supreme Court decision in the matter of interim independent commission, which expressed that rules of constitutional interpretation do not favor formalistic or positivist approaches, and that every style of constitution compels a broad and flexible approach to interpretation. And I reproduce segments of that judgment there. Given those principles of constitutional interpretation, the High Court was right in the methodology it employed in interpreting the constitutional provisions from a historical and contextual perspective, and the complaint that the court misapprehended the methodology applicable is not well-founded. What then is the doctrine of basic structure, and was the High Court right in holding that it applies in Kenya? In an article for the Center for Public Interest Uganda titled "The Basic Structure Doctrine and Constitutional Restraint, Take Away from Age Limit Decision," Benson Tusariwe writes that the doctrine of basic structure holds that the Constitution has certain basic features which underlie not just the letter, but also the spirit of that Constitution. These features constitute the inviolable core of the Constitution, and any amendment which purports to alter the Constitution in a manner that takes away that basic structure is void and of no effect. That even without explicit limitations to the constitutional amendment power, there are implied constitutional limitations to the nature and scope of constitutional amendments by which the Constitution should not be amended in a way that changes features of the Constitution that form its basic structure. The doctrine rests on the distinction between original or primary power to make or effect radical changes in the Constitution, vis-a-vis secondary power to amend or effect minor changes on the Constitution. Under the doctrine, the decision to make fundamental changes to the Constitution is a matter solely reserved for the people, the Constituent Assembly. Courts may invalidate any exercise of the derivative amendment power that proposes to violate the Constitution's basic structure. Constitutional amendments may be found to be infirm because of the actual proposed content of the amendments that will replace the Constitution and not just amend it. Yaniv Rosnai, who was widely quoted by counsel in both sides in this case, states in his book, Unconstitutional Amendments, The Limit of Amendment Powers, that under the doctrine, the amendment power is not unlimited. Rather, it does not include the power to abrogate or change the identity of the Constitution or its basic features, and that any organ established within the constitutional scheme to amend the Constitution, however unlimited it may be in terms of explicit language, cannot modify the basic pillars underpinning its constitutional authority so as to change the Constitution's identity. The other phraseology used in reference to the doctrine of basic structure is quote-unquote unconstitutional constitutional amendments, UCA. In the article, Democratic Erosion, Populist Constitutionalism, and the Unconstitutional Constitutional Amendments Doctrine, Yaniv Rosnai again, with Tamar Brandes, argue, and I quote, One feature of modern constitutionalism that is especially relevant for constitutional change is that of constitutional unamendability. Constitutional unamendability refers to the limitations or restrictions imposed upon constitutional amendment powers from amending certain constitutional rules, values, or institutions, end of quote. They argue that unamendability may appear in the form of an explicit, unamendable constitutional provision, or may also be judicially imposed when the court derives such limitations implicitly from the Constitution, declaring that certain constitutional changes are strictly prohibited. They say that unamendability aims to protect the core values of the Constitution that express, in a way, its constitutional identity. And again, I have quoted from their work there at length. The doctrine, therefore, distinguishes amendment, properly so called, and dismemberment of the Constitution. Again, I cite a passage which I think has already been referred to by one of my colleagues from Richard Albert, Constitutional Amendments, that makes the point. As is evident from the material presented by both sides of the argument, the doctrine of basic structure is not new to our jurisprudence. It was acknowledged and applied by Rengera J. in the case of Joya and others, in the context of determining whether Parliament could enact a new constitution in exercise of its amendment power under Section 47 of the retired Constitution. Section 47 of the retired Constitution provided that subject to that section, Parliament may alter the Constitution. Justice Rengera found that Parliament had no power under the provisions of Section 47 of the Constitution to abrogate the Constitution and or enact a new one in its place. In reaching that conclusion, the judge found support in the dicta from the Supreme Court case of Kesavanda. And I have quoted that and also passages from Minerva Mills Limited. And then I have said as follows. In the end, Rengera J. endorsed the view that every provision in the Constitution could be amended, provided in the result the basic foundations and structure of the Constitution remains the same. And there are other passages from that decision that have already been cited, and so I will skip them. There is also the decision of the High Court in the case of Commission for Implementation of the Constitution versus National Assembly, where Lenaola J., as he then was, expressed that the basic structure of the Constitution, which is commonly known as the architecture and design of the Constitution, ensures that the Constitution possesses an internal consistency deriving from certain unalterable constitutional values and principles, and that where the basic structure of the design and architecture of our Constitution is under threat, this court can genuinely intervene and protect the Constitution. In short, the doctrine of basic structure and the pillars on which it is founded has been recognized and applied by our courts and is very much part of our jurisprudence. It is not as alien a concept as perhaps some of the appellants argued in this case. In his book, Presidentialism in Commonwealth Africa, Professor Nabweze, in his discourse on abolition and attenuation of restrictions on the amendment power, discusses what he terms as the assault on the independence constitution of Kenya, which resulted in quote-unquote sweeping away of restrictions that had been entrenched with regard to alteration provisions. He states that the assault, culminating with what he refers to as the final stage, where an amendment could be made by a unicameral National Assembly with 65% majority, less than the usual two-thirds. Against that backdrop, he argues, and I quote, "A constitution is supposed to be a permanent charter, which is to endure for all ages to come, not to be lightly altered to meet the temporary expediency of party politics. If the procedure for its amendment is not sufficiently rigid, and the temptation to alter it in accordance with the fancy or interest of the party in power is succumbed to over readily, the Constitution loses its sanctity in authority of the bedrock of constitutionalism and may become instead a mockery of the very idea of a government of laws. This is not to say that a constitution should be made unduly rigid, since that might invite its overthrow by revolutionary means when a genuine need for change has risen and cannot be effected constitutionally. He goes on to say that it may even be considered that the need for a constitution that is able to evolve with changing social and political conditions is perhaps greatest in a developing country. And then says that the really fundamental aspects of a constitution should be immune from alteration without reference. The really fundamental aspects of a constitution should be immune from alteration without reference to the people. He goes on to note, to give experiences, I think, from other jurisdictions in Africa. And I therefore then conclude that there is abundant authority, therefore, based on which the High Court concluded that the doctrine of basic structure applies in Kenya. What does all this mean in the context of the Constitution and the present appeals? It is perhaps in the manner of the application of that doctrine in the context of Chapter 16 of the Constitution where my perspective somewhat differs from that of the High Court. The journey of the Constitution of Kenya 2010 is well documented in the final report of CKRC, as well as the final report of the Committee of Experts on Constitutional Review. The High Court, in this case, also gave that account. The Committee of Experts concluded in its report that, quote, the new Constitution of Kenya is a compromise and none of the interest groups, including the Constitution, the Committee of Experts itself, politicians and the religious sector, and the Kenyans at large got all that they wanted. But Kenyans must stand tall in the knowledge of having bestowed on themselves and future generations a constitution of their own and one that corresponds to their will and aspirations for a better, peaceful, and prosperous future. And that what remains is to be vigilant in ensuring that the new constitution is implemented in the way in which it is designed to be. As I have already stated, the High Court in the present case found that in the making of the Constitution of Kenya 2010, Kenyans were insistent on the four sequential processes in the form of civic education, public participation and collation of views, constituent assembly debate, consultations, public discourse, and ultimately a referendum to ratify the Constitution. According to the High Court, Kenyans intended that the constitutional order they so painstakingly made would only be fundamentally altered or remade through a similarly informed and participatory process, and that it is clear that Kenyans intended that each of the four steps in the constitution making would be necessary before they denatured or replaced the social contract they bequeathed themselves in the form of Constitution of Kenya 2010. I understand the High Court to say that in making the Constitution of Kenya, Kenyans adopted a rigorous process involving the four stated steps to make it. To remake it or to fundamentally alter it, an equally rigorous process, as was used in making it, must be undertaken. In that finding, the High Court appreciated, correctly in my view, that a distinction must be made between amendment of the Constitution and abolition or annulment of the Constitution. For if what is proposed as an amendment is not in fact an amendment, then the provisions in the Constitution on amendment cannot be used to abrogate the Constitution. In his article, Constitutional Amendment and Dismemberment, Richard Albert argues, and I quote, the impetus behind the theory of constitutional dismemberment is that some constitutional amendments are not amendments at all. They are self-conscious efforts to repudiate the essential characteristics of the Constitution and to destroy its foundations. They dismantle the basic structure of the Constitution while at the same time building a new foundation rooted in principles contrary to the old. These constitutional changes entail substantial consequences for the whole of law and society. End of quote. Abolishing or abrogating provisions of the Constitution in such a way as to alter its foundation and structure is therefore not envisaged under Chapter 16 of the Constitution. That is a preserve of the people exercising sovereign power, which belongs to them in accordance with Article 1 of the Constitution. To that extent, I am in agreement with the High Court. As I have stated, it is in the manner of the application of that doctrine, given the text of Chapter 16, where I take a different path. According to the High Court, the identification of whether a provision of Constitution is part of the basic structure is a matter of analysis on a case-to-case basis. In the words of the High Court, quote, whether a particular clause in the Constitution consists of an amendable clause or not will be fact-intensive determination to be made after due analysis of the Constitution, its foundational structure, its text, its internal coherence, and the history of the clause and the constitutional history, and other non-legal considerations permitted by our canon of constitutional interpretation principles, end of quote. On my part, I am persuaded that the framers of the Constitution identified for all to know what the basic structure of our Constitution is. In what learned counsel referred to as the hierarchy of norms, the framers set out in Article 255(1) of the Constitution what they identified to be the fundamental pillars that define the Constitution. Those provisions are amendable in the sense in which I have referred to that word as meaning minor revision, addition, or modification in contradistinction to dismemberment in accordance with Article 257. Provided the amendments proposed do not amount to an abrogation or dismemberment of the Constitution, they are permissible. But even then, such amendment not amounting to dismemberment of the matter set out in Article 255(1) of the Constitution must be done in accordance with Article 257. In other words, the doctrine of basic structure, as I understand it, is a complete bar to dismemberment or abolition of provisions of the Constitution in the name of amendment. Abolishing or abrogating those provisions cannot be an amendment within the purview of Chapter 16 of the Constitution. On the other hand, under the Constitution, all provisions of the Constitution are amendable in the sense of correcting, modifying, clarifying, improving, or expounding without fundamentally altering the identity of the Constitution. The matrix, as I see it, is that if a proposed change to the Constitution is a dismemberment of the Constitution, then Chapter 16 provisions are not available. If, on the other hand, the proposed change is an amendment, properly so called, then the next question is whether it relates to a matter set out in Article 255(1) of the Constitution. If so, then the provisions of 257 must be invoked. If it does not touch on any matter set out in 255(1), then the amendment may be pursued via the parliamentary initiative route under 256. Ultimately, however, whether a particular proposed amendment is strictly that or a disguised attempt to abrogate the Constitution is a matter for judicial interpretation. Based on the foregoing, my conclusion in relation to the basic structure doctrine is that it is applicable in Kenya. In its application in the context of our Constitution, it bars the dismemberment, replacement, or abolition of the Constitution in the name of amendment. The Constitution does not envisage, contemplate, or permit its replacement, abrogation, or its dismemberment. That is a preserve of the people and can only be done by the people outside the framework of the Constitution, following the procedure used or akin to that used to make the Constitution, and which must include civic education, public assembly debate, and ultimately a referendum. The doctrine does not, in my view, prevent genuine amendments to the Constitution. The framers of the Constitution identified the matter set out in Article 255(1) of the Constitution as the core or the basic structure of the Constitution, and any amendments properly so called to the Constitution relating to or touching on those matters can be done in accordance with Article 257, infused with the national values and principles. Whether a proposed amendment amounts to a dismemberment, abolition, or derogation of the Constitution is, as I have stated, ultimately a matter of judicial interpretation. Any other amendment to the Constitution that does not relate or touch to those matters can be made in accordance with 256. In my view, there are no eternity clauses in the Constitution. I then look at the scope of popular initiative and public participation, and I conclude as follows. Having considered the rival arguments on the remit of popular initiative and popular participation, the issues arising are whether an amendment of the Constitution by popular initiative is a preserve of the citizen, whether the President or the Executive can initiate amendment through the popular initiative, who was the promoter in this case, what is the scope of public participation in that regard. And I set out the provisions of Article 257, which I will not read. And I then say that on the face of those provisions, there is no qualification of who may or may not promote a popular initiative. As correctly submitted by counsel for the appellants, there is no explicit bar against any person, including the president, from promoting a constitutional amendment by popular initiative. It is not, as it were, in the black letter of Chapter 16 of the Constitution who may or may not propose an amendment. It is a matter of interpretation in accordance with the principles of constitutional interpretation to which reference has already been made. And then I go on and say, in the end, the framers of the Constitution separated the route which the elected representatives can take for amending the Constitution through parliamentary initiative under Article 256, and the route which the citizen can take through popular initiative under 257. Although the phrase popular initiative is not defined in the Constitution, the background I have set out above and the lexical meaning of the word popular lend credence to the conclusion reached by the High Court that the amendment by popular initiative under Article 257 is the preserve of the citizen. The concise Oxford English Dictionary, for example, the word popular is defined as including intended for or suited to the taste or means of the general public. Merriam-Webster Dictionary also defines the word popular to mean of or relating to the general public. In both definitions, the phrase general public features, and I do not think the president or the executive would fall under the category of general public. In reaching this conclusion, I am cognizant of the provisions of Articles 19, 20, 22, 24, and 38 of the Constitution and the contention that the holder of the office of the president, like every citizen, is entitled to enjoy rights under the Bill of Rights. However, it seems to me that the curtailment in certain respects of those rights in relation to the holder of the office of the president is sanctioned by the Constitution, given the constitutional role assigned to the holder of that office in the process. As to who the promoters with respect to the Constitution Amendment Bill is concerned, I will just summarize that and say, I take the view that the process began with a handshake, followed by the establishment by the president of the task force. Thereafter, the president established the BBI steering committee, whose mandate included proposing constitutional reforms. The BBI steering committee generated the Constitution Amendment Bill. The president and Honorable Railaand Odinga then flagged off the signature collection. The Constitution Amendment Bill and the list of voters supporting was then delivered to IEBC by Honorable Mohammed and Honorable BBI National Secretariat. And I then say it is a continuous process, it is a continuum. It is unnecessary, in my view, to attempt to split that process to justify the claim that the process towards initiating the popular initiative began with the delivery of the draft amendment bill and supporting signatures to IBC, and to ignore what preceded that. The delivery of the draft bill and supporting signatures to IBC was part of a process that had begun before the generation of the draft amendment bill by the steering committee. In my view, all the players in that process, beginning with the president, Honorable Railaand Odinga, the BBI steering committee, Honorable Mohammed, Honorable Uhuru, qualify as promoters in a continuum that preceded the delivery of the bill. I do not think there is merit in the contention that the president's involvement in the amendment process was in his capacity as a private citizen. The material presented shows otherwise. The Kenya Gazette notices based on which the task force and steering committee, whose mandate, as I have mentioned, included consideration of proposals for amendment of the Constitution, are testament that the president was acting in an official capacity. And then regarding public participation, I have made reference to the guidelines that were given by the Supreme Court of Kenya in the British American tobacco case, and I have set those out. And then I have said that there can be no question, therefore, that public participation is a fundamental constitutional principle in our country, a major pillar and bedrock of our democracy and good governance, to quote the words of retired Chief Justice Mutunga in the matter of the National Land Commission. It is a constitutional command that it must be infused or integrated into the amendment process under Chapter 16. And then I set out other arguments, and then I conclude that I am therefore in agreement with the High Court that there is a legal requirement under Article 10 of the Constitution for voters to be supplied with adequate information to make informed decisions. There is no evidence that that was done in this case. I would not go as far as the High Court did in prescribing in minute detail how public participation might be undertaken. As the Supreme Court stated in British American tobacco case, allegation of lack of public participation must be considered within the peculiar circumstances of each case, and the mode, degree, scope, and extent of public participation is to be determined on a case-to-case basis. It is perhaps also a matter for the legislature to prescribe in appropriate legislation the scope and breadth of public participation, short of which the court is left to apply the standard of reasonableness on a case-to-case basis. To be clear, I take the view that amendment, properly so called, of matters touching or relating to Article 255 is achievable through what the High Court referred to as secondary constituent power, namely public participation and referendum. And then I deal briefly with the issue of verification. And then I say as follows. Having considered the arguments, I take the following view. The role of IEBC upon delivery of the draft bill proposing amendment to the Constitution by popular initiative is set out in Article 257(4). In an affidavit sworn on 25th of February 2021, Michael Goa, a Director of Legal and Public Affairs of IEBC, deposed that IEBC received the draft amendment bill on 10th December 2010, accompanied by 4.4 million supporters' signatures, upon which it issued a press release on 18th December informing the public of the same. That IEBC carried out a process to confirm that the said initiative was supported by the signatures of at least 1 million registered voters in order to ensure compliance with the requirements of Article 257. That after completion of that process, an interim report was prepared during which data cleaning exercise by removing incomplete records, including missing signatures, ID numbers, names, duplicates, and those not in register. And that a list of verified supporters was uploaded on IEBC's website to enable them to check and confirm their details. That the purpose of uploading the list of verified supporters on the website was to provide an opportunity for objection by anyone who had been captured as a supporter without their consent. That upon completion of that process, it was established that the popular initiative met the constitutional threshold and the amendment bill was transmitted to the county assemblies. Based on the depositions in that affidavit, the finding by the High Court that the role of IEBC under Article 257(4) entails ascertaining the number of registered voters in support of a popular initiative to amend the Constitution and verifying that the initiative is indeed supported by the registered voters claimed to be in support is correct. As submitted by Council, the verification of signatures of supporters of the Constitutional Amendment initiatives entailed ascertainment of whether they were registered voters and had appended their signatures. The controversy appears to be with regard to precisely how IEBC was to execute or carry out the verification. According to IEBC, that would be achieved by posting the list of voters claimed to have supported the initiative on its website for scrutiny, with an invitation that any objections should be raised within a given period. The respondents, on the other hand, argue that IEBC should itself have undertaken a forensic examination. In the case of National Super Alliance versus IEBC, the court stated that courts cannot step in to police or prefect independent constitutional bodies or direct them how to carry out their own mandates, unless there is willful neglect or violation of their constitutional or statutory functions. And the independent commissions are clothed with discretion and latitude to decide the governance process or the procedure to employ as to how and when to execute their mandate, as long as it is within the law, and that this operational and functional independence has constitutional underpinning. So guided, the question is whether IEBC properly discharged its verification mandate under Article 257(4). The record shows that IEBC uploaded the list of signatories in support of the initiative on its website on 21st of January 2021. The closing date for scrutiny and for any objections to be taken was indicated to be Monday, 25th January. Under item Q and R of Part B on verification procedure of IEBC's administrative procedures, it states that after actual signature verification exercise and documentation, the compiled list of supporters is published in the Commission's website for information and verification for 2 weeks. Publishing the list of supporters over a weekend was clearly in violation of IEBC's own prescribed time frame of 2 weeks. The time provided for scrutiny and for raising objections was grossly insufficient. Why IEBC was in such a rush is not clear. Secondly, there is the question whether merely uploading the list on IEBC's website without more is sufficient. Would it have been more effective for IEBC to, in addition to uploading the list on its website, to publicize the matter in other media as well? These questions are germane and bolster the argument that a comprehensive legal or regulatory framework for the conduct of referendum is important. In my view, had the IEBC given sufficient notice, opportunity, and means to the public to interrogate the list of verified supporters of the initiative, it would perhaps have been considered to have been discharged its duty of ascertaining and verifying that the registered voters who had indicated as supporting had indeed done so. That said, the conclusion by the High Court that IEBC's role under 254 involved both ascertainment of numbers of registered voters in support of a popular initiative to amend the Constitution, as well as verification of the authenticity of those signatures, is partially correct in my view. Yes, IEBC is required to ascertain that the threshold of 1 million registered voters is met. Secondly, it must verify or establish or confirm that those voters whose names that have been submitted have in fact endorsed the initiative. That, as I have stated, is in my view achievable if IEBC affords reasonable means and opportunity for the voters to interrogate and confirm their endorsement of that initiative. That said, this discussion is further testimony of the need for legislative and regulatory framework for matters relating to Article 257. I then move on to look at the regulatory and legal framework, and I think I'll just go to the conclusion. And I say this, there is undoubtedly, therefore, some legal framework, albeit not an elaborate one, for the conduct of referendum, even though it may not specifically address or fully address all aspects of a referendum, including matters of collection, presentation, and verification under Article 257 of the Constitution. I do not doubt, as I have mentioned, that it is important to have specifically tailored legislation that specifically and fully addresses matters relating to Article 257. Indeed, there is realization in that regard, as it was demonstrated that there are 2 pending bills before the National Assembly in that regard. That said, I agree with the High Court that notwithstanding the absence of an enabling legislation as regards the conduct of referendum, such constitutional process may still be undertaken as long as the constitutional expectations, values, and principles and objects are met, and that in doing so, the process must be in strict compliance with inter alia Article 10 of the Constitution, which prescribes the national values and principles, and that those principles must be infused at every stage of the process. That statement is consistent with the legal principle exemplified by a decision of this court in IEBC versus National Super Alliance, where this court reversed a finding by the High Court invalidating procurement of ballot papers without legislative framework to facilitate a meaningful program of public participation. In doing so, this court expressed, and I quote, "The absence of a legal framework for public participation is not an excuse for a procuring entity or a state organ to fail to undertake public participation if required by the Constitution or law. A state organ or procuring entity is expected to give effect to constitutional principles relating to public participation in a manner that satisfies the values and principles of the Constitution. End of quote. Equally, the absence of a legal framework per se cannot be a basis for asserting that IEBC should not discharge its constitutional mandate under Article 257. There is also the High Court decision in Titus Alila, where the question whether there was a proper legislative framework for holding a referendum arose, and the High Court found that the Constitution has already set up a proper legislative framework. In my view, therefore, the declaration by the High Court that the absence of a legislation or legal framework to govern the collection, presentation, and verification of signatures and other conduct of referenda renders the attempt to amend the Constitution through the Constitution of Kenya Amendment Bill flawed, even though qualified with a statement in the circumstances of this case, is one I am respectively unable to endorse. To the extent I construe it to mean that IEBC cannot, absent specific legislation on conduct of referenda, conduct referendum under Article 257. There is then the matter of IEBC's administrative procedures. And on that, I capture the arguments and then say that whereas the administrative practices were not avowedly made in exercise of the Commission's power under Section 31 of the Act, in a replying affidavit sworn by Michael Goa of IEBC, he deposed that the administrative procedures were developed pursuant to Section 55 and Regulation 98 of the Election General Regulations 2012, after extensive public participation. Accordingly, based on Michael Goa's deposition, the administrative procedures fall within the statutory definition as they are made or established in execution of a power conferred by or under an act of Parliament, under which that statutory instrument or subsidiary legislation is expressly authorized. Moreover, this court can only interfere with the decision of the High Court if it is established that the High Court misdirected itself in law and that the decision is plainly wrong. On the matter of quorum, I say this. My view is as follows. Section 5.1 of the Independent Electoral and Boundaries Commission provides that the Commission shall consist of a chairperson and 6 other members, appointed in accordance with Article 254 of the Constitution and the provisions of the IEBC Act. Section 5.3 provides that the process of replacement of a chairperson or member of the Commission shall commence at least 6 months before the lapse of the term of the chairperson or member of the Commission. Section 5.4 provides that the procedure set out in the first schedule shall apply, which with necessary modifications, whenever there is a vacancy in the Commission. Section 7A of the IEBC Act provides that the office of the chairperson or a member of the Commission shall become vacant if the holder dies, resigns from office, or is removed under circumstances specified in Article 251 and Chapter 6 of the Constitution. Under Section 7A(2) of the IEBC Act, the President is required to publish a notice of vacancy in the Gazette within 7 days of the occurrence of such vacancy, and the process of recruitment, quote, shall commence immediately after the declaration of the vacancy by the President, end of quote. Section 8 of the Act provides that the conduct and regulation of the business and affairs of the Commission shall be as provided for in the second schedule, but subject thereto, the Commission may regulate its own procedure. Paragraph 5 to 7 of the second schedule, prior to amendments introduced through the Election Laws Amendment Act number 34 of 2017, provided, and I have reproduced those provisions there, I will not read them, and then I say that through Election Laws Amendment Act 34, paragraphs 5 and 7 of the second schedule are repealed and replaced with those provisions. Paragraph 8, which was not affected, of the second schedule, provided that subject to paragraph 5, no proceedings of the commission shall be invalid by reason only of a vacancy among the members thereof. Those amendments were successfully challenged and declared unconstitutional by the High Court in Katiba Institute case, and I have cited passages from the judgment of Justice Muita, which are there. IBC contends that as paragraphs 5 and 7, as previously enacted, had been repealed, the declaration by the High Court invalidating the amendments did not revive the repealed provisions. It was urged that by relying on provisions of paragraphs 5 and 7 of the second schedule, as they existed prior to the amending provisions being declared unconstitutional, the court relied on non-existent provisions, and therefore Article 250, which sets the minimum at 3, applied. Respectfully, I do not understand the decision of the Supreme Court in the case of Mary Wambui, which was cited as supporting the proposition put forth by IBC. If I understand the argument correctly, it is that the effect of the declaration of unconstitutionality by the High Court of the provisions of the Election Laws Amendment Act number 34 that had sought to amend paragraphs 5 and 7 of the schedule is that the schedule is now silent on quorum. That there is in effect no longer a provision and therefore recourse must be had to Article 250. I am not entirely persuaded by that argument. Article 250 of the Constitution does not, with respect, address the question of quorum of the Commission. It is a provision on composition. It sets the minimum number of persons who must make up the Commission. Quorum speaks to the minimum number of commissioners that must be present to make a binding decision. It speaks to the number of commissioners who, when duly assembled, are legally competent to transact the business of the Commission. As defined in Black's Law Dictionary, it is the minimum number of members who must be present for a deliberative assembly to legally transact business. Article 250 of the Constitution cannot therefore fill the gap which the IBC says was created by the declaration of unconstitutionality of the provisions that had sought to amend paragraphs 5 and 7 of the second schedule. In the case of Mary Wambui, the Supreme Court in paragraph 87 of the judgment expressed as follows. However, while we have pronounced ourselves on the issue of invalidity of Section 76(1) of the Elections Act, in line with the Constitution, this court is not precluded from considering the application of the principles of retroactivity or proactivity on a case-to-case basis. I then look at the decisions they cited there, including the decision by Justice Kriegler in the South African case of Sias Moise, and I then go on to say that the decision of the High Court in the case of Katiba Institute was silent on the effective date of the declaration of unconstitutionality. Based on the decision of the Supreme Court, I take the view that the default position is that the declaration of unconstitutionality related back to when the unconstitutional provisions were enacted, with the result, in my respective view, that the status quo ante was restored. Therefore, the requirement of quorum of 5 applies. I am therefore in agreement with the High Court that when it pronounced in the judgment that IBC Act categorically places the quorum of IBC for purposes of transacting business at 5 commissioners, and that IBC did not have that quorum at the time it made the consequential decision related to the Constitution of Kenya Amendment Bill. IBC also contended that the impugned decision of the High Court runs afoul of a subsisting decision in rem in a constitutional matter, in the case of Isaiah B. Watt, which has been extensively cited. And I'll cut through and just say, I am conscious that this court is not presently sitting on appeal from the judgment of Isaiah B. Watt. However, it seems to me that quite apart from reading into the text of paragraph 5 of the schedule, the words policy decisions, and apart from mixing up composition with quorum, the learned judge appears to have either overlooked or infused statutory provisions with what she considered to be common sense when she stated, quote, "My take is that the issue of quorum, apart from being a matter provided for under the statute, is also a matter of common sense and construction. depending on the total number of commissioners. And then I have the rest of the passage, and then I say, further, in making that pronouncement, the learned judge does not appear to have considered the provisions of paragraph 8 of the second schedule, which provides, subject to paragraph 5, no proceedings of the commission shall be invalid by reason only of a vacancy among the members thereof. Under that provision, the requirement under paragraph 5 is overriding. The pronouncement by the judge in the above cited passage appears, therefore, to be an abrogation of a statutory provision, and to that extent is per incuriam. Consequently, the High Court in the present case was entitled, for that reason, among other reasons the court gave, to depart from it. Moreover, the statutory commands in the IBC Act, if heeded and complied with, would have ensured that the number of commissioners would not have fallen below the number required to form a quorum. For those reasons, the complaint regarding the findings by the High Court as to quorum have no merit. I then move on to the issue of continuous voter registration, and I think I'll just say what I concluded. The High Court cannot therefore be faulted for having concluded, as it did, that there was no evidence that IEBC had discharged its obligation of continuous voter registration. I would therefore not interfere with the decision of the High Court. The last aspect I think I'll look at, separate and distinct referendum questions. On that I say, in my reading of those provisions, that is of the Constitution, it is the bill in which an amendment proposal is contained that is submitted to the people to vote on in the referendum by indicating whether they agree or disagree with the amendment proposal, much in the same way as the members of the county assemblies and members of the houses of parliament would have signified their approval or disapproval of the amendment process in the draft bill. It seems to me, therefore, that under Article 257(10) of the Constitution, as read with other provisions in that article, what is envisaged of the voter at the referendum is for the voter to make a choice to ratify or not to ratify, to approve or not to approve the amendment proposal in the draft bill. However, that choice, in my view, is rendered nugatory, inoperative, and consequential if the voter is called upon to vote on an omnibus draft bill that contains a raft of numerous, diverse, and unrelated proposed amendments to the Constitution, in this case over 70 proposals, that cut across the entire spectrum of the Constitution. And I cite the passage there from the High Court decision entitled Alila. The argument made for the respondents on the principle of unity of content or single subject matter, that constitutional amendment through a referendum should deal only with one main issue, is one I find most attractive and persuasive. It was argued that under that principle, the proposed amendment should deal with one subject only to allow the voter to form and express their opinion freely and genuinely. In other words, if a proposed constitutional amendment includes several substantive questions, the voter may not have a free choice, that each proposed constitutional amendment ought to secure adoption on its own merits, not on the merits of other different proposals to which it is attached, and that there must be an intrinsic connection between the various parts of each question to put to the vote in order to guarantee freedom of suffrage